and there was an interim order also. So, but I would like to first request to Lordship to come to the complaint, written complaint, my lord.
Why there are two cases, one CRR, one WP?
Yes, ma'am. I am the petitioner of the CRR case, ma'am. On the last occasion when your lordship was hearing the case, ma'am, it was pleaded by the respondent that a petition for police inaction. The petition for police inaction is filed on the same FIR. So your lordship thought it to be proper to tag the cases and
So that's why who has filed the WP?
WPA is filed by this Anindra.
Who is he?
He is the private respondent in my case.
In your CRR?
The de facto complainant, my lord.
He is the de facto complainant.
Yes.
What he filed in the, what he paid for in the writ application?
My lord, in the writ application, what he paid, he is not, I am not served with it, my lord, but then
You are not a party to the writ petition?
I am not served with it yet.
You are not the party to the writ petition?
I am the party to the writ petition, my lord. There are two more parties, my lord.
Who is appearing for the writ petitioner?
Mr. Rajdeep Majumdar in the matter. My lord, we just came to know that the petitioner's father, who is the actual complainant in the case, he has passed away last month. So, Mr. Majumdar has requested some time on behalf of the petitioner that if some adjournment may be given till after the vacation. My lord, the complaint at the shop, he's the actual person against whom all this litigation is going on. So, my lord, some time may be given, my lord.
I may be allowed to, but this is going on for the last many months. I'm really sympathetic towards that demise of the petitioner's father, my lord. But this case needs to be heard out, my lord. Once I may be given only to clarify my points, my purpose.
But what will purpose it is if they are not ready?
My lord,
If they are not ready, I will hear you, and the case could not be disposed of.
My lord, this is a clear abuse of the process of law.
Okay, when you will be available?
my lord, 1 week's time we need
1
some.
week now.
20th.
My lord, anything next.
What is the CRR?
The CRR is mine, my lord.
For what? Quashing?
Quashing of the FIR and the proceedings, my lord.
Okay. Okay, come on. 20th.
Grateful,
As
my
per the
lords.
prayer made by the council for the private respondent. You are for the private respondent?
Yes,
Opposite party in the CRR?
opposite party.
Opposite party. The case is adjourned. Let the matter appear on 20th February.
Grateful,
20th
my
May.
lords.
I came now about 70.
Yes.
I requested for some time.
Huh?
I need to file some additional documents in
What is the prayer? What is the case? What you have prayed for, sir?
Quashing lordship.
Quashing of?
Quashing of FIR.
What is the section?
Section is under 126, 150, 117 of the.
What are the ground?
I need to file some additional documents.
Document? You have not filed the charge. How you file the document in the criminal revision?
We have preferred.
Criminal revision is to be decided on the basis of the charge sheet, documents available in the charge sheet only.
Lordship, I have also filed a complaint against the de facto complaint. I need to obtain some certified copies.
Huh?
I need to obtain some certified copies
For what?
for supplementary affidavit.
Sir, this is 482 application.
Lordship,
Correct.
that is.
You have filed an application of quashing of the one proceeding. The quashing of the proceeding depends upon the materials available in the charge sheet.
Lordship.
Correct. So you cannot rely upon any further document which is not the document in the charge sheet.
Lordship, but I have preferred the petition over here.
You cannot change the law.
I'm not changing all the law. So I have also complained. I have also made a complaint against the de facto complaint in this case.
Correct.
So I need to obtain some document to prove my point.
Huh?
I need to obtain some document to prove my point.
From other document, how you can prove, how the court can allow you the additional document which is not the part of the charge sheet. If you want to rely upon certain documents on your defense, you go for the trial. How the additional document can be considered that at the time of quashing of the hearing of the quashing application?
thing is, can we go in your facts of the case, Lordship?
Hmm.
Lordship, on 22/3/2023,
Correct.
purchased a flat in that building. Lordship, after that, just after 1 month, the de facto husband of the de facto complainant asking me huge sum of money was because I have settled over there. He was asking me 5 lakh rupees. And on 17/4/2023, I made a complaint against them in Siliguri police station. Lordship, and subsequently after that, they started. When I stopped, I denied giving them money. They started harassing me. The aged parents of the petitioner, Lordship. The petitioner went to the job, and the parents of the petitioner that over here is being harassed by the husband of the de facto complainant, Lordship. And that is, I also annexed my Lordship, can come to the page 21 of my application. Since 18/4/2023, I have been complaining against it.
Page
21 of my application.
21. Yes. It is the 18/4/2023.
2023.
Correct.
After that also, Lordship, when they are starting creating disturbance, the petitioner here wants to install some CCTV camera in the flat. So they have the husband of the de facto company along with some other associate objectives with the same Lordship. With the intervention of the police personnel, we can install the CCTV camera, Lordship. Even that also has been annexed. The complaint has been annexed over here in page 22, Lordship. Since when I entered into that flat from that day, Lordship, they are harassing me, Lordship. On the day of incident, Lordship, I was the victim on the case, Lordship. They have beaten the petitioner, they have beaten the father and mother of the petitioner, Lordship. I need to avail some certain on that case, Lordship. I need to that document from the piece.
So what has happened to your, what the complaint you have filed, what has happened to your complaint?
Lordship, charge sheet has been filed, but
That is also the complaint is there.
Lordship, I have prepared so many applications, Lordship.
In that case also the charge sheet is filed.
Lordship.
Correct. In this case
And
also filed.
Two FIR has been lost from my side, from the father of the petitioner, Lordship.
Correct.
In one case, charge sheet has been filed, other is pending, Lordship.
Pending.
Lordship, I have been complaining since 2023, Lordship.
So what is the ground of quashing of this FIR and this proceeding?
I need some document, Lordship. Kindly.
Sir, again and again I am telling, for the 482 you cannot adduce any further document than the document available in the charge sheet.
Lordship.
You show this court what are the documents and statement. This is not covered for the alleged offense, so offense is not been made out. The court can, this court cannot go the third document. So yes, this is your document, that third document, if you are relying upon, you go to the trial, produce the document during the evidence, either DW or cross-examination, and you prove that. But that is not in the 482 proceedings.
Lordship, on the principle of Bhajan land, if I have been harassed from since 2023, Lordship. This complaint is lodged maliciously. They are previously just to harass the petitioner, Lordship.
So that's why I'm telling, show me what are the material. You are telling that this material is not correct, which prima facie do not made out the case under the offense which the police has filed the charge sheet.
The charge sheet of the application annexed to page 51.
Yes,
Can I read it, please?
yes.
The accused person, what I am the religious portion of it. The accused person lives in a flat below the same building. He kept talking in the common gate like every day, and when my husband protested, he started beating my husband. Then I tried to save my husband. He tried to steal her by throttling, also threatened her with a dire consequence. He put 6 hands in the breast and molestation was disturbed her wearing aprons. In regard of the wearing of this, no wearing apron has been seized. Lordship can see the seizure list. There is a nil seizure list. There is a CCTV camera also fit on that premises of the building, but the police has not.
That is not the ground. CCTV camera is not seized. That is not the ground with regard to the 482. Okay, Caesar is not there. Then
On 17/4/2022, the accused gave me a bad photo on the road on the suicide as legal recorded the case and endorsement for the investigation. Subsequently, Lordship, on that night only, I have been, when I called the police personnel, they came in court, they took the petitioner for medical purpose and they put him behind the court. The aged parents of the petitioner waited around this whole night for it. When they went to the police station, they realized that the son has been arrested.
What is your good name? Vasudev.
Lohan.
Huh? Vasudev, your client?
Vasudev Bhattacharya.
Vasudev Bhattacharya.
LIC Saurabh.
Only one accused.
Only one accused. They have not made a complaint against the aged parents of the petitioner. They have made just to as this petition.
Yes. That's all. That's all.
Lordship, I have preferred a read also against them.
Huh?
I have preferred a read application against them.
Huh.
But that is for fact, I need to file some document.
Yes, who is for the state?
Nobody. It's been a motion state.
I don't know what the case you made out for the 482 satisfied this court, then only the notice will be issued, sir.
Let me.
Only because the seizure is not made you and the CCTV is not footage is not seized, whether this is a ground for the quashing of the FIR.
I've been complaining against them since 2023.
So you have made a complaint, already 2 FIR has been chalked out. In one case the charge sheet has been filed, one case is the investigation is pending.
107 has been issued against them not to break the peace, Lordship, but they still today, Lordship, they always harass us, Lordship. They close our door.
So what can be done in the if suppose today the charge sheet it is caused, that incident will be stopped. Then
But I need to obtain that document, Lordship, relating to both the cases. So I think.
so suffering for the petitioner, counsel for the petitioner press for time to and press for you to file supplementary affidavit. Let supplementary affidavit file within 2 weeks. After serving 2 weeks, let the matter appear before the next circuit bench.
Most of them.
I take no more review on.
Yes.
This is an application where we have challenged the order of proclamation.
Why
Lordship,
proclamation is issued?
Lordship, I need not argue much, Lordship. Kindly see the order dated 15/3/2025.
15-3.
3.
Yes.
Now,
You are Sujit Ghosh, Sunil Das.
Lordship.
Accused Pradeep
Now-
is present.
Yes, Lordship. He was arrested, Lordship. May I read along, Lordship?
Yes.
The IO of the case submitted charge sheet. Such and such under 306 IPC, the accused person Prashanjit Rai, Pradeep Chaudhuri, Sunil Das, Subhash Das, Sujit Kumar Ghosh, alias Kala. Pursuant to the city and other materials of the case, there are sufficient materials against the accused person such and such. Cognizance is taken for offence punishable under 306 IPC. So, Lordship, 82(4), if this 306 does not come under the purview. Lordship knows better than me. The IO of the case for issuing WA against accused. ER of WA already been issued against
You have the
accused.
case prayed for issuing WA against the accused person, Prasanjit Ray.
Prashanjit Ray.
Huh.
Prashanjit Ray. No, and Pradeep Chaudhuri is in custody. Lordship.
Okay, okay.
There are other accused persons.
So-
ER of WA already been issued against the accused. Lordship, ER of WA has been issued. Let's take it away. Now on 28 to 25, Liu WA accused not issued. Or I don't find it. Maybe it has not been issued, but order was first made.
Already been against this.
In the case, IO has not sent up such and such. To me, accused as expert on author, accordingly, period is allowed for the end of justice. Hence, the case against the accused author is filed to 26/3/2025 for production ER of WA. Now, next page, Lordship, can you see? Next page.
ER of WA against whom?
Against other accused person who against whom the WA was issued. Maybe.
Prasanjit.
Prashanjit and others, Lordship. Can you see? Prashanjit, Sunil Das, Subhash Roy, Sujit Kumar Ghosh, alias Kala.
No.
That is 1, 2, 3, 4th paragraph, Lordship.
Yes.
As I understood. Lordship. Now, next page, second order dated 26/3/2025. No ER of WA is received.
from Vaisi Bhaktinagar in respect of accused Prosenjit, Sunil, Subhash, and Sujit Kumar Gaur Kela.
Issue proclamation.
So that's my lordship. And another, no 30 days, no specific time, nothing. I need not.
Where is the report of ER?
Actually, without the execution report of the warrant of arrest.
Even execution report even received indirectly, you cannot. There are other procedures.
There is other procedure.
Lordship, no date is mentioned. Lordship, see the next date, not even 30 days. No time and space, place mentioned. I may not argue much.
Which?
But
City and
it is-
Jalpaiguri. Why you not gone for the session judge? Why you not gone?
Lordship, we should not know, sir.
Yes.
Actually, this is a case under section 306. Subsequently, section 304 was also added because
Whatever it may be.
whatever it may be.
Not against that person.
Whatever it may be.
Against
Even
protester.
302.
Even 302.
Even
Actually,
302.
the law is set.
But with regarding the proclamation, there are procedure.
This procedure is not.
And without the prayer of the IU, how the court
Ah.
can so much to issue the
And
proclamation?
on my right under 5438 is gone. Lordship.
The law is settled. Lordship.
But you are also absent. How without appearing before the term.
Lordship, I was filing the application
Okay.
under 438.
I filed.
We'll file because this thing has happened.
So and so suffering for the petitioner.
Objection may kindly be noted.
So and so suffering for the state police staff. The petitioners have filed the present application for setting aside the order passed by, but 306, no?
306.
Charge sheet is filed in the charge sheet, whether the, what, you are having the charge sheet?
Yes.
What the status has been shown with regard to these two accused persons? Absconding?
Absconding. Warrant.
Absconding?
In the charge sheet, abscond.
Absconding. And what you have prayed for?
WPA may kindly be issued.
Directly.
हाँ, क्या बोला? Passed by the learned Chief Judicial Magistrate Jalpaiguri. Jalpaiguri dated 26th of March 2025, wherein the London magistrate has issued the proclamation against the petitioners. Counsel for the petitioner submitted the after the investigation, the police has filed the charge sheet before the London Court of Chief Judicial Magistrate, being charge sheet number 160 of 2025 under section 160 of 2025 dated 16th of March 2025 under section 306 of the IPC against the accused persons, including the petitioners hearing.
304 was also added.
Not against the petitioner. Against the
Here only
not
the-
sent up. Accused not sent
As
up.
per this order, I am full stop. On receipt of the charge sheet, the London magistrate has taken cognizance and found that the accused persons and had issued warrant of arrest against the accused persons and fixed the date on 26th of March 2025 for production of the accused for production and ER of WA. For production.
One in Lajesh. 304 has been added against all the accused persons.
No, its cognizance is only 306. I am cognizance.
What is the problem, Lordship?
What? How they are
Against the
preparing
person
the
not sent up, 300.
Be bench clerk cognizance. It's called bench clerk.
bench clerk cognizance.
Police. The matter was taken up for hearing on 26th of March 2025, and the London magistrate found that no ERFW is produced. Accordingly, the London magistrate had issued the proclamation against the petitioners. The counsel for the petitioner submitted that the warrant was issued on 15th of March 2023, and immediately, without waiting for a period of 30 days, the London magistrate had issued proclamation on 26th of March 2025. London counsel for the petition further submitted before issuance of the proclamation, the London Chief Judicial Magistrate, Jalpaiguri, London magistrate failed to comply with the other provisions of the CRPC. per contact and an advocate appearing for the state submit that these petitioners are the accused in the present case, but during the investigation also, the police has raided several places, but failed to. Police has raided several places, but the police could not able to arrest the petitioners, and accordingly, the police has submitted the charge sheet against all the accused persons, including these petitioners, and showing the status of these petitioners as absconded accused persons. Accordingly, London magistrate had issued the warrant of arrest, and the warrant has not been executed. Warrant is not executed. Executed only for protection of the accused, the London magistrate had issued proclamation. He submitted there is nothing illegal in the order, and the application filed by the petition is liable to be rejected. Had the London counsel for the respective parties peruse the materials on record. Though the police has filed the charge sheet showing the petitioners as absconded accused persons, and after taking cognizance by the London magistrate, the magistrate had issued warrant of arrest against the petitioners by an order dated 5th of March 2025, and fixing the date for returnable of the warrant on 26th of March 2025. On 26th of March 2025, no report is submitted by the police authority with regard to the warrant of arrest. Even no prayer was made for issuance of the proclamation, but the London magistrate so motu has issued the proclamation without following the procedure. Accordingly, this court finds that the magistrate has exceeds the jurisdiction by issuing the proclamation without following the procedure before issuance of proclamation. Thus, the order dated 26th of March 2025 with regard to issuance of the proclamation against the petitioners are set aside. Now, 15th of March warrant. Proclamation. Warrant is not wrong.
Warrant is not.
Lordship, the charge sheet shows 304 against the person who is already dead and 300.
I am not going PRR number so in this court.
Grateful, Lordship. Number 72.
Item number 72 of the investigation.
Yes.
This is a case for washing.
Washing off. What is the allegation? What is the section?
Allegations are in section 420 and 408 of the IPC. So I'm relying on the ground that several grounds there of which from that I'm challenging the FIR, the charge sheet, and the proceedings in general. This case emanates from a corruption case that has happened in Kujvihar in the post office. Lordship, what has happened subsequently?
Who are you?
I am the petitioner. Lordship. I am one of the.
What you are the government servant?
I was a contractual government servant. I was not a government servant general. I was employed the contractual.
What is the allegation against you?
The allegation is that of receiving. In
which department you are working?
I was working in the postal department. Postal department, the crux is that there was a payment made.
A recurring account?
Not recurring account, Lordship, it was a POSB account. If I'm not wrong. The postal account, and out there a payment was made, of which I was not aware of.
Payment was made,
It
is not disclosed in the account.
No, payment was made, but and then I, believing it to be my money, I withdrew it. And thereafter the things started to go. What happened, Lordship, if I may? The complainant in this case is also an accused, if I name accused in another case, emanating from same event.
Circumstance. Yes.
Same event.
Who is the complainant?
The complainant's name is Mr. One.
No, what is his post in the postal department?
Possibly he's a superintendent, if I may check for one, Lordship. It's there in the FIR. Kindly give me a minute.
Subdivision inspector of police, yes, post office.
He's
a competent person.
He made the FIR, but he's also an accused in the another FIR. Now, the reason why I'm saying that is because it's that another FIR which I have annexed in my document, in my petition, that offense has also emanates from this event itself. My
contention is that I was not aware of the situation, I was not aware how the payment was made, and thereafter I was just a victim of circumstances. It also can
The
be
payment
seen
has not come to your account.
Lordship,
The payment has not transferred to your account.
it was transferred, and I believe I am accepting it. I believing it to be my money. I withdrew it. There was total. There was the allegation is as per the FIR. There was a.
What is the total amount you have received?
I have received 5 lakhs, but in the FIR, if your lordship kindly peruse this, they said there has been a fraudulent transaction, an illegal transaction of 25 lakhs, of which I have received or I have withdrew, whatever
5
it may be, of 5 lakhs. Now, I believe it's not very uncommon in rural areas to have 5 lakh rupees in the postal account. I believe it's my money, I withdrew it. Thereafter, things started to roll. That is my contention that relying which I have.
So your belief, whether your belief can be decided in the 482 application or your
Lordship,
belief is
regarding
to
that-
be proved in the
No,
trial?
Lordship, it's not regarding the belief. It's
Hmm.
regarding the various the points of law on which I have. I will be relying on certain judgments, certain decisions for which I unfortunately I couldn't obtain today. The matter was just filed yesterday. Unfortunately, couldn't obtain. That's why I'm praying if it can be fixed on Monday or Monday, if your lordship please. Because I believe it's I have genuine ground. Also,
Yes, sir. Tell me what is the ground? First is your belief. Second is
no, Lordship, that's all I will show it to you, Lordship, kindly, if you Lordship kindly fix it Monday. Moreover, Lordship, the court, the trial court, the CGM Kuch Bihar, they have also given favorable observations, which I would like to show it to your Lordship. If your Lordship kindly allow.
what observation?
Lordship, it's regarding, I've annexed it in my. On one of the orders, Lordship, and the thing is that currently the petitioner, he is working as a software developer. So he made an application before the learned trial court Kuch Bihar, the learned CGM Kuch Bihar, to allow him to visit abroad due to his job purpose in order to earn his livelihood. Now, out there, a favorable observation was made that there was ever since the petitioner has received bail, the accused has received bail, he has never evaded the trial, nor has he not cooperated with the authorities, and never ever a warrant of arrest had to be issued to compel his appearance. Now, regarding all these sets of events, all these facts, I would like to place your lordship the fact before you. Only because of that, I am praying for Monday, because also I couldn't obtain the judgments.
Sensation suffering for the petitioner. Petitioner has filed the present application for quashing of the proceeding in connection with Kotwali PS case number
281
of 2017 dated 8th April 2017 under section 420-408 of the IPC pending before the Learned Chief Judicial Magistrate Kuch Bihar being GR case number 354 of 2017. Counsel for the petitioner prays for accommodation. According to case adjourned, let the matter appear 21st May.
Kindly fix this out Monday, lordship, if it's possible.
Not
Or as your lordship pleases, 21st.
21st.
Get it.
Next.
It's over 73.
What is the matter? Why the service? 376 and you prayed for quashing. Huh? To whom you want to served upon them? Is a revision. The revision first you have to satisfy the court, then the service will come. Tell like this. Who is your senior? Huh? He will not come here. Because this is a tough court.
Somewhere it was there in head case of the complicated.
Where is? Alipur. Big court. This is a small court. 2 days.
No, Alipur is from there.
He is for them there. So he is visiting the jungle. Monday.
Number 74.
Yes. What is the good name? Panchang Singh Bhutia. Yes.
The incident actually happened from 19th of November 2019 to 26th of January 2020. So after 3 years and 7 months, this is the company that is filed before the police. If I may read it what it says, I, the below sign, would like to draw your kind attention towards the fact that the above two persons had conducted to be contracted, had conducted to provide RBM. RBM is riverbed material. So in the nature of aggregate sand and to their company, that is Arjun Enterprise, having their office at Pudivadi, Kodlawadi. And as they said, I started providing them RBM with my truck. So he's a transporter. From the date of 19/11/2019, and since then, one by one, almost constantly, I started giving them RBM. This place as per their company's demand. Thus, one by one, I gave them about 45 days, 320 trips. Loaded with RBM with my truck numbers, whatever, up to the date of 26 January 2020. So
Correct.
often starts from 19/11/2019 and ends on 26 January 2020. But the situation started changing from when I started asking them my dues. My rightful dues amount to 1,38,872. So per trip, it is coming out to 430 rupees per trip. I have not received it till date, and therefore this complaint has been launched. Now I have understood that they have completely cheated me. They made a deal with me, and I had supplied the RBM to them, but they did not give me the money till today. They and their company had cheated me, misappropriated me with a qualified intention, invested my money and not paying me back, which I should pay. Based upon this matter, a charge sheet has been filed. Page 28 not supposed to be the charge sheet.
Yes.
In the third last paragraph, during investigation of the case, there were two IOs. The first IO goes away, the second IO comes in. During investigation of the case, the prima facie case under section 406, read with 420. IPC has well been established against the two accused person. He has consulted his superior officer. The superior officer also were of the opinion that 406 read with 420 is made out, and therefore the charge sheet has been. And what's the cognizance has also been taken. If I can have my sheet for a moment for the cognizance order that is dated 23rd of April 2025. Simple one-liner saying cognizance is taken, offense under 406 428. Now my contention before
24th April.
Yes. My contention before my lordship is 406. In one of the order, which my lordship find has been annexed with this reasonable application, it is at page 23, when one of the accused person applied for an anticipatory bail. My lordship in the division bench.
23.
Page 23.
Yes.
At serial number 4, my lordship has specifically observed this for our notes that both section 406 and 420 have been added in the affair, which are mutually exclusive. Despite that, the charge sheet has been filed, and despite that, the cognizance section taken. Now, I am relying upon one judgment of the Honorable Supreme Court, the celebrated case of Lady Race Club. First of all, I will have my lordship to the scope of a civil case giving a color of a criminal offense, and for that I am relying upon starting with para 10. Para 10.
Yes.
This also was a case wherein certain horse food were supplied to a race club, and thereafter the payments were not done. The case at hand is one of an unpaid seller. It is a case of a complainant that he used to regularly supply consignments of grain and oats for horses at the Delhi Race Club. The complainant used to raise invoices in favor of the club, and the club used to pay the requisite amount. However, according to the complainant, after 2017, the club stopped the making payments, and there was due of certain such amounts. Para 12. We have the view that even if the entire case of the complainant is accepted as no offense, what the name is disclosed. Para 13 was last line. The order of the magistrate summoning the accused must reflect that he has applied his mind to the facts of the case and the law applicable thereto. He has to examine the nature of the allegation made in the complaint and the evidence before doing that. Then, my lordship, para 24 to 27, wherein the scope of as to what a breach of trust and what is the cheating, and that has been explained. Para 13 is important. I'll be relying upon the last 6 lines in para 30.
Para 30.
Last 3 lines in para 30.
Yes.
There is a distinction between criminal breach of trust and cheating. For cheating,
Paragraph
paragraph 30 means 30.
30. Yes.
Last 3 lines. There is a distinction between criminal breach of trust and cheating. For cheating, criminal intention is necessary at the time of making a false or misleading declaration. Since inception, in the criminal breach of trust, mere proof of entrustment is sufficient. Thus, in the case of criminal breach of trust, the offender is lawfully entrusted with the property and it dishonestly misappropriated the same. Whereas, in case of cheating, the offender fraudulently or dishonestly induces a person by deceiving to deliver any property. And the last line, in such a situation, both the offences cannot coexist simultaneously. And then, this has again been reiterated in para 43 with a very strong observation. The Honorable Supreme Court said that the police officer who does that needs to go for a training. At para 53, it is high time that the police officers across the country are imparted proper training in law so as to understand the fine distinction between the offence of cheating vis-a-vis criminal breach of trust. Both offences are independent and distinct. The two offences cannot exist simultaneously in the same set of facts. Now, in my case, what has happened was that not only a civil case has been given the contours of a criminal offence, but at the same time was 406 read with 420, and the cognizance has also been taken note, and the charge sheet has also been filed. That was
It's true, my lord, it's true that it's an admitted fact that the 406 and 422 cannot go simultaneously in the and it is true, but there is a case regarding the cheating. They have for the very inception they are intent to not pay the amount. That's why the 420 will can be considered, but 406 and 420 cannot run together. It's settled principle of law, your lordships.
So all the civil court will be closed and all the
No, there is another remedy also.
all the money suits will be direct.
Lordship, there is another remedy also, my lord. You understand?
Go to the civil court. Go
Yes,
to the,
go for the money shoot and the rest.
no,
The provision.
no, all the civil magistrate will be given the criminal charges and police, the plaintiffs will be directed to go to the police station and they will.
Lordship.
That's my perspective.
Yes, settled law. Lord.
Since inception, there has to be a intent. That is also not the intent.
Yes.
One of the prime from the very inception intention and there is a breach of trust. Both cannot run together, my lord. It's true. It's settled law. But thing is, there is a grievance that they took the articles and they did not pay. But is your lordship rightly that there is a provision for the recovery of the money, another forum, my lord. So if they particular one section 406 or 420, it's maybe a case of 420, not my.
Okay.
I'll leave up to the lordships. Lordship
all.
knows my stance.
Yes.
Charge sheet has been filed, my lord.
So appearing for the petitioner, so appearing for the state. Hearing concluded. CAV.
Yeah, we will check this.
Item number 75.
May it please your lordship, my lord, I appear for the petitioner. My lord, the petitioner is 81 years old. My lord, we have assailed an order issuing a warrant of arrest against the petitioner.
Chamber में भेजना. Yes.
My lord, may it please your lordship, my lord, I appear for the petitioner. The petitioner is 81 years old.
Yes.
My lord, we have assailed an order issuing warrant of arrest. If my lord's pleasure may be to kindly come to page 84, my lord. Well, what had happened, the learned magistrate was pleased to dispense with the personal appearance of the petitioner and permit him to appear by his pleader. That order is at page 84, my lord.
So you are enjoying the 205. So you
My
are.
lord, yes, my lord. So there was 205. Now, my lord, if my yes, my lord. Now, my lord, kindly sees the last part of that particular order. The personal attendance was dispensed with, excepting on the date fixed for charge, examination of accused under section 213, as well as the time of pronouncing of
Correct.
judgment. Now, if my lord's pleasure will be to, now, if my lord's pleasure will be to kindly come to.
What you
in the
prayed
meanwhile,
for?
we had filed-
What you prayed for?
But what had happened, the learned magistrate has issued a warrant of arrest. We have prayed for setting aside of the warrant of arrest. In the interim, we had approached the learned sessions court. The learned sessions court had held our application to be non-maintainable, considering that the order issuing warrant of arrest was an interlocutory order. But therefore, my lord, we have come up before your lordships, my lord, under section 482. My lord.
So once the
If my lord kindly sees,
sir, you have not appeared. What was the stage of the case when you have not appeared?
Yes, my lord, kindly sees
What was
page
the stage?
320. We had filed a discharge application. We
No,
had filed a
no.
discharge application under section.
That is correct. That is correct. You file the discharge application, whatever it may be. By an order, the London magistrate has allowed you to appear before the court through by applying the 304, 205 and 2 or 3 points as the dates have been
My lord,
has been given when you
on
have
the date fixed for
before the-
framing of charge.
Where is the order
My
of
lord,
the
yes.
warrant? Where is the order issued warrant against you?
My lord, kindly sees page 320. Kindly sees page
Page?
320. My lord.
320.
320. Yes, my lord. Kindly sees the first order, my lord, 30th of March 2022.
320.
My lord, yes, my lord. 30th of March 2022 is the first order. My lord, kindly sees today is the date fixed for hearing of the petition filed by the accused persons under section 239. My lord,
Yes.
knows best that 239 is for discharge. Now, my lord, 14th of June is fixed for hearing of the petition dated filed by the accused persons under section 239 CRPC.
Right.
My lord, kindly sees the 14th of June order. But in that it says today is fixed for hearing of petition and consideration of charge. Learned advocate for the accused persons files a time petition for hearing on the lawyer's ground. Considered the prayer is allowed. So the discharge application is allowed to be adjourned. Thereafter, all the accused persons file a time petition. Considered the prayer is rejected. Issue warrant of arrest against the accused persons. Now, your lordship knows best, that if the discharge application, it precedes section 239, precedes section 240, which is for framing of charge. But under section 239, if the application stands allowed, then there is no question of framing of charge. So, the discharge application was allowed to be adjourned. That prayer was allowed. If the discharge application is kept in abeyance, the question of framing of charge may not arise. And therefore, in my respectful submission, the condition of section 205, which was to appear personally at the stage of consideration, at the stage of framing of charge, which is under 240. But that stage had not arrived because the section 239 application was pending, and that was the prayer for adjournment was allowed. Therefore, the question of personal attendance under 240, section 240, was kept in was also required to be put in abeyance. But the magistrate was pleased to issue a warrant of arrest. But that apart, your lordship knows that in Satendra until the Honorable Supreme Court, my learned colleague is there.
Now, where is the
copy of the judgment will be.
Where is the order of the session judge?
That is at page 328, page 328, I'm sorry, page 326, 326 it starts. The relevant part, these ordered part is page 328.
Yes.
The only issue before the session judge was that it's an interlocutory order. Yes.
Yes.
This petitioner is 81 years old. He's being represented all along by his learned counsel, and the discharge application is pending as on date.
What is the case? What is the charge leveled against you?
It's a case of 406, 409. The allegation is that the of non-remittance of provident fund dues.
It is a GR case or CR case? GR case?
It's a it's a GR case. GR case. GR case.
Yes.
The petitioner is 81 years old, but he's being represented by a learned advocate all along, and there's been no remissness on his part on that front. And the discharge application is pending as on date. Even today, it's pending for consideration. It's subject to my lord's kind sanction. If the discharge application may be heard out, and if the outcome is if the discharge is allowed, then perhaps there will be no question of framing of charge. But if the discharge is rejected, then the petitioner will be bound to appear before the magistrate personally.
Yes.
It's only because of his ill health.
Yes, who is appearing for the state?
This one I'll appear. I'll appear.
You will appear. When? Today ready? Yes. You are appearing. So the copy. 205 warrant was there.
Well, days 81 years old.
No, not 81. 205 is there.
205.
Hearing of 229 application. Hearing of 229 application, presence of this not required. If that has been rejected, if the case is fixed for consideration of charge, then only the presence is required.
That's true. 3 occasions presence are required.
And he has stated
Consideration of church at the time of his
13, 313 and judgment.
possibly judgment.
Judgment. Even the judgment, sometimes it found that it
Yes,
is,
they can file 317 also in this case, my lord.
no, through 205 is allowed, then the 317 will not.
Not required, but even then they can file.
Yes.
I'm late by Mr. Dutt.
Yes. Right. Other it was CRF.
So suffering for the petitioner. Learned public prosecutor is present.
Correct, no?
The petitioner has
Sulpat
filed
to
the present
present.
application. Praying for setting aside the order passed by the London. Which court? Leonard, Additional Chief Justice Magistrate.
No, my lord, it's presently before the learned magistrate, my lord, third court,
Leonard Judicial Magistrate.
Alipurdwar.
Third court, Alipurdwar, Jalpaiguri. In GR case number 414 of 2022, 2002. 2002, dated 30th. Dated 14th June 2022. 14th June 2022, wherein the London magistrate had issued the warrant of arrest against the petitioners and the order passed by the London Session Judge, Additional Session Judge, Alipurdwar, passed in criminal revision number 47 of 2022, dated 8th April 2025, wherein the London Additional Session Judge has dismissed the revisional application filed by the petitioner challenging the order of the London magistrate dated 14th June 2022. Counsel for the petitioner submitted. Counsel for the petitioner submitted. The petitioner, both petitioners, sole or one? Two petitioner, one. The
One petitioner, single petitioner.
The petitioner is aged about 81 years and is not in a position to appear before the London magistrate on each and every date of hearing. And accordingly, the petitioner has filed an application under section 205 of the Code of Criminal Procedure for dispense with his personal appearance on each and every date of hearing, and allowing the London counsel for the petitioner to appear before the London court in the absence of the petitioner. Full stop. The application filed by the petitioner under section 205 of the CRPC was disposed of by the London magistrate by an order dated 20th March 2014 by passing the following order. This page 85A. Page 85A. 85A, हाँ? बीच में. Full stop. As the petitioner was enjoying the leave granted by the London magistrate under section 205 of the Code of Criminal Procedure, and the petitioner is appearing before the London magistrate through the London advocate. Full stop. During the pendency of full stop. In during the pendency of the case, the petitioner has filed an application under section 239 of the CRPC for discharge. Full stop. The application was fixed on 30th March 2022. Accordingly, but due to the bar resolution, the case was adjourned, and the London magistrate has fixed the matter on 14th June 2022 for hearing of the application. No, for consideration of charge.
No, my lord, it was for hearing of the discharge application.
Hearing of the application filed by the petitioner for discharge. On 14/6/2022, as the case was fixed for hearing of the petition filed by the petitioner for discharge, but the London magistrate found that the petitioner has not appeared. Accordingly, warrant of arrest was issued without taking into consideration that by an order dated At 23rd of March 2014, the petitioner has been allowed to represent under section 205 of the CRPC. Being agreed with the said order, among the learned, the petitioner has preferred a revisional application, but the learned session judge has also rejected the said application on the ground that the order issuing warrant is the interlocutory order, and as such a revision is not applicable. Full stop. And not maintainable. Full stop. At the learned counsel, full stop. At the learned counsel for the respective parties peruse the materials on record. This could find that by an order dated 23rd of 20 March 2014, the London magistrate has allowed the application filed by the petitioner under section 205 and categorically directed that the petitioner has and in the order, the London magistrate has directed that the petitioner shall appear before the London court at the time of examination of the accused under section 313 and pronouncement of the judgment of further directed by the court as and when required. But on 14th June 2022, the case was fixed for hearing of the application filed by the petitioner for discharge. On the said date, there was no direction by the London magistrate upon the petitioner to appear the petitioner in person. But the London magistrate has issued the warrant of arrest. Considering the above, this could find that once the magistrate has allowed the application under section 205 of the CRPC and the petitioner has not violated the condition of the order dated 20 March 2014 and is appearing through the learned counsel and has also filed an application for discharge and on 14th of June 2022, this case was fixed for hearing of the application and there was no direction by the London magistrate upon the petitioner to appear in person on the date fixed. But without taking into consideration, the London magistrate has issued the warrant of arrest against the petitioner. In my view, the said order by issuing the warrant against the petitioner, though the London magistrate has allowed the application under section 205 and there was no direction upon the petitioner to appear before the London magistrate on 14/6/2022. Accordingly, the order dated 14 June 2022 is not sustained under law and the same is set aside in cause. Consequently, the order passed by the learned session judge by an order dated 8th of April 2025 in criminal division number 47 of 2023 also set aside and cast.
Deeply obliged.
The London magistrate is directed. This order will not prevent the London magistrate that any direction can be passed upon the petitioner as and when required by the London magistrate for appearance of the petitioner in person before the London magistrate.
Let's be grateful.
Deeply obliged, my lord. Deeply grateful. my lord.
Next.
Item number 76.
एक बजे होगा पॉक्सो होगा इन कैमरा होगा.
No, I am for the state in this
My
matter.
lord, for the petitioner in this case, my lord, this is an application for crossing of a charge sheet, and the charge sheet was filed under section 447, 427, and 506 of
May I hand up this
24
to you?
IPC. 447 deals with a criminal trespass, entering or remaining in the property of another person, and 427 is mischief, causing damage to the tune of ₹50 or more. And a third is criminal intimidation, threat, or alarm.
What you are doing?
Now, my lord.
You are
my lord.
government servant.
No.
Go plead guilty.
The
500 rupees.
My lord, it is basically a civil dispute which has been given a criminal color, and it is actually a land dispute. If I kindly come to the FIR, it's at page 16.
Page 16.
Yes, my lord. My lord, the FIR is completely vague and does not attract the essential ingredients of the offense. Now, my lord, I'm reading the FIR. The de facto complainant is Arati Sarkar, and directly coming to the allegation, my husband, 1, 2, 3, fourth line. My husband, Sri.
Where from you're reading? Page 16?
Yes, page 16, FIR, fourth line, my lord. The de facto is
Yes,
Arati
my husband.
Sarkar.
Yes, my husband.
My husband, Sri late Manoranjan Sarkar, bought a land measuring about 10 decimal or 6 kathas from Sri Gopal Chetri, son of Lal Bahadur Chetri of Kotia Jodh, deed number 2608-2000 and Khatian number 2313. The allegation is regarding the criminal trespass, but the police has not seized any document regarding the ownership of the land. Now, next, my lord, all these years, the land was under my control and there was peace. But suddenly, my lord, the date and time of the alleged incident has not been mentioned. But suddenly now, Sri Karmal Oraon, who is the father of the present petitioner, but now he has expired, Karmal Oraon, son of late Sukha Oraon, and Sri Sankar Oraon, who is the petitioner in this case, son of Karmal Oraon, both residing at Kotia Jodh. After my husband's death, these people now mistreats me and also uses bad words at me whenever I step on my land. Mentioned above.
Yes.
They also remove all the wooden sticks which I used as a boundary of my land. My lord, these wooden sticks have not been seized. Therefore, the question of mischief also does not come. Damage to the tune of rupees 50 or more. And also not allow for any construction work to be carried out in my said land. These people also scares us, saying they will beat us if we ever step into that land. My lord, if we come to the charge sheet, my lord, after page number 37.
Yes.
Second last page of the charge sheet.
Yes.
My lord, second paragraph, third last line. I sent a prayer. My lord, second last page of the chart sheet, third last line of the second paragraph.
Yes.
I sent a prayer addressing to the BL and LRO, Naxalbari, for ownership, verification of the land, actual particular of the said land owner. But no any report at BLLRO till now. Therefore, my lord, as there is no proper document with regard to the ownership of the land, the question of criminal trespass will not be attracted.
I sent a prayer addressing to the BLR and LRO Naxalbai for
Most probably owner verification of
verification of the land, actual land owner, but no any report of the BLO has been till now. By this time, I consulted. Then you consulted and filed charge sheet.
Yes, my lord.
Correct.
I'm coming to page number 20. My lord, the present FIR is the counterblast of several FIRs which were lodged by the father of the present petitioner. The land belongs to the father of the present petitioner, and there are documents in that regard. Page number 19, Karmal Oraon, the name has been mentioned in this Khatiyan. Page number 20, Karmal Oraon. Page number 21. The present FIR is the counterblast. In the page number 21, my lord, if you read the this page number 21, this was lodged by the father of the present petitioner. The allegation is with regard to the same land, and the allegation is put against the present de facto complainant and her husband. What is the allegation? V. Karmal Oraon is the father of the present petitioner. 1, 2, 4th line, my lord. That Srimati Arti Sarkar, who is the de facto, and Sri Manoranjan Sarkar, resident of Dash, forcibly trying to construct our land in our land and also occupy the land situated. So this is basically there are FIR and counter FIR.
What has happened to this? Is there any FIR is chalked out against this report?
No.
Then therefore again the FIR was lost this FIR was lost in the year 2015. Subsequently, another FIR was lost in the year 2021 regarding the same land and against the daughter of the present de facto complainant and other persons. Page number 22, my lord. And again, page number 24. In page number 24, my lord, it is written in Bengali. Jomi Dokhal.
So whatever it is, but how the court can go into this documents at present?
My lord, the present FIR is a counterblast of the several complaints which was lodged by the father of the present petitioner. And my lord, the ingredients of the offence are not attracted. Secondly, my lord, in the FIR, the word suddenly has been written that suddenly on such and such date, they have removed.
What is the section? 447, 447, 427.
Criminal intimidation. Criminal trespass will not be attracted on the ground, my lord. The police in the charge sheet has clearly stated that the FIR, the LRO has not given any document with regard to the ownership of the land. So no, till now, my lord, there is no such document to prove the ownership.
Yes.
And secondly, my lord, one more point, my lord. If you kindly come to, my lord, one more point. If you kindly come to the page number 32, my lord. Page number 32 and 33. Why the word suddenly has been mentioned in the FIR, my lord? Why the FIR is vague with regard
32,
to
33.
Yes, page number 32 and 33.
Yes.
Page number 32, my lord.
Yes.
The present FIR was lodged on 6/5/2022.
Correct.
My lord, but if you see this document at page number 32, the date of examination is 7/5/2022. The present petitioner was at the this Banaras Hindu University. He was he continued to remain there at Banaras and preparing for his examinations, which are going to be held on 7/5/2022, and the FIR is 6/5/2022. Secondly, my lord, 33, page number 33. The proof that he was continuously in the Banaras Hindu University, there are several dates which have been imposed in this document. It is a no due certificate document, and several dates have been mentioned, like he was continuously during that period of time, and this was the only reason, my lord, the FIR, the allegation starts with the word suddenly. The FIR is not specific with regard to the date and time, which makes the FIR vague and omnibus. And secondly, my lord, no document with regard to the ownership. Hence, the ingredient of criminal trespass will not be attracted. Therefore, and it is a civil dispute, and this case is just a counterblast.
My lord, I have handed up the CD, my lord. I have gone through the FIR, but I cannot
Where is
assist.
the report? He has encroached the land of the complainant.
My lord, there is a seizure of deed at page
447. Criminal trespass.
My lord.
Criminal trespass, where is the report that he has encroached the land of the complainant? One thing. Then your investigating officer in the charge sheet itself stated that he has requested the BLRO for providing the document. Document was not given, but his senior officer has advised to file the charge sheet. Is file the charge sheet. So if the ownership and the trespass is not proved, where is the 447 and 427 will come? And with regard to the 427, where is the assessment?
Assessment is not there.
Where is the evidence? Come after lunch. Come at 2.
My lord, actually, my lord, I cannot read Hindi. Most of the 161 statements are written in Hindi.
I am well conversant with Hindi.
That is why I remained silent.
Yes.
77, just miss the file.
77. After that. Yes, so call 1 p.m. In camera matter, please, I request the members to go. Mute कर दो, mute कर दो. Yes. Where is the report? Where is the land record? Nothing.
Only a seizure of a deed is there, at page
Seizure
5.
of?
Deed,
Where is that?
page 5. my lord. And 161 I could not read, my lord. At page 18, 19, 20, 21.
So and so,
My lord, a strong objection may be recorded.
so and so appearing for the petitioner. So and so appearing for the estate. The petitioner has filed the present application under section 482. 401 of the 482 of the Code of Criminal Procedure. Praying for quashing of the charge sheet and the proceeding against the petitioner initiated in connection with Jalpaiguri PS case number 98 of 2022, dated 6th May 2022, under section 447, 427, 4506, 34 of the IPC, pending before the in GR case corresponding to GR case number 2003 of 2022, pending before the Learned Additional Chief Judicial Magistrate at Siliguri. Police. Counsel for the petition is that on 6th of May 2022, a complaint has been made against the petitioner on the allegation that petitioners, two petitioners,
One petitioner, one is already expired.
one expired.
Yes.
Against the petitioner on the allegation that the petitioners have illegally trespassed into the property of the complainant and has committed mischief, and also threatened the complainant. On the basis of the said complaint, the above mentioned FIR has been initiated. Full stop. Counsel for the petitioner submit that it is the specific case of the complainant that the petitioner has entered into the land of the complainant and committed mischief. After the initiation of the case, the police investigated into matter and the filed charge sheet for the offense under section 447, 427, 506 of the 34 of the IPC. But during the investigation, the investigating authorities have not collected any document from the concerned authority to prove that the land is recorded in the name of the complainant. The investigating officer has also not seized any material or taken any photographs to prima facie prove that the petitioner has committed mischief by damaging the property of the complainant. For example, the counsel for the petitioner draw the attention of this court to the charge sheet wherein the charge sheeting officer has categorically stated that the investigating officer has sent a request to the BLNRO Jalpaiguri for
Ownership verification.
Of the landed property, but the authority has not submitted any counsel for the petition submitted. It is the specific case of the prosecution that the investigating officer has requested the concerned authority for obtaining verification report of the land in question, and the the concerned authority has not provided any details or report to the investigating officer, and without obtaining any report or to ascertain whether the petitioner and whether the complainant has and whether the complainant is the owner of the property or whether the petitioner has entered into the property. Counsel for the petitioner submit that the complainant has lodged the above case only on 5th of June, the 6th of May 2022 by alleging that suddenly the petitioner has entered into the property in question. But the investigating officer during the investigation failed to appreciate that the dispute between the petitioner and the de facto complainant is very old, and the petitioner has made several complaints against the de facto complainant, but the police authorities has not taken any action against the de facto complainant. On the other hand, taking into consideration the son of the petitioner in the examination,
Son of
the son of the petitioner, the examination which you have shown the document, na? The
the petitioner itself.
petitioner itself. The
Father died.
Father.
the petitioner was the student and is appearing in the examination, and the petitioner was not present here, but in spite of the same, the police authority has submitted charge sheets against the petitioner. Per contra, Learned Counsel for the state submit that on receipt of the complaint form, the police has investigated into the matter and found that the complaint filed by the complainant is correct, and several materials have been collected. Statement of the witnesses have been recorded wherein it is prima facie proved that the petitioner has illegally criminal trespassed into the land of the complainant and has also committed mischief by damaging the crops, by damaging the property of the complainant. Police counsel for the state submits that there are sufficient materials on record to prove the case against the petitioner, and at this stage, if the proceeding is quashed, the prosecution will be badly prejudiced. Had the Learned Counsel for the respective parties produce the materials on record. In the complaint dated 6th May 2022, it is the specific case of the complainant that the petitioner, along with his father, have entered into the land of the complainant and have damaged the boundary and committed mischief, against which the petitioner has against which the police has initiated the case under section 447, 424, /506, /34 of the IPC. The investigating after the initiation of the case, the police has investigated into the matter. To establish the case under section 447 of the of the IPC, the investigating officer has to collect the evidence whether the property in question which the complainant is claiming is recorded is the owner of the property, or whether he is having right over the property. But in the present case, it is found that there is no document seized by the investigating officer to prove that the complainant is owner or is having any right. On the other word, in the charge sheet, the investigating officer categorically mentioned that he has made a request to the BL and RO for providing the document with regard to the ownership of the said property, but no document was produced. In spite of the same, the investigating officer has submitted charge. As regard the ingredients of 427, the prosecution has to prove with regard to the damage of the property to say that the petitioner has committed mischief. There is no seizure to say that the damaged property was seized. There is no photograph to show that the petitioner has committed, has damaged any crops or any property of the of the complainant. Only on the basis of the verbal statement, the police has submitted the charge sheet. As regard the offence under section 506, this court did not find any material with regard to the alleged offence. Considering the above, this court finds that though the police has submitted the charge sheet, but this court did not find any material that any case is made out against the petitioner, either for the petitioner for the offence under section 447/424, 427 or /506 of the IPC. In view of the above, CRR number, in view of the above, the proceeding in connection with Naxalbari PS case number 98 of 2022, dated 6th May 2022, corresponding under section 447, 427, 506/34 of the IPC, corresponding to which culminated being charge sheet number 275 of 2022, dated 25th of December 2022, under section 447, 427, 506, 24 IPC, corresponding to GR case number 2003 of 2022, pending before the London Additional Chief Judicial Magistrate of Siliguri, are set aside and quashed. The petition is discharged from the jail bond. CRR numbers consistency displayed. Obliged. Next. Yes.
Hello, appealing for the petitioner.
You are for the.
We have come against an FIR. And which culminated to a charge sheet dated 39/2018 under section 420, 406, 34.
2018. What is the section 406?
Read with 420.
So if the first go, these two doesn't go together.
Yes, then.
My lord, it was a kind of allegation that the petitioner was connected or managing the affairs of a company which was running allegedly cheat fund. And subsequently, one of the depositors who had to run there to collect his due money, he was refused. And on the apprehension of his money being siphoned out, and FIR was lodged to the police. Police started investigation. Well, four salient features I will draw your kind attention to. Number one is the date of the complaint was 27/11/2014, my lord.
Yes.
Charge sheet was submitted almost after 4 years, that is 39/2018.
2018.
18.
8 years.
My lord, the petitioner resigned from the company on 21/9/2011. Long before the FIR was registered, and his such resignation was accepted by a board resolution on 12/10/2011, and which was subsequently on 1st of April 2013, the company uploaded it in the website. Though the company has not made an action, the director, as a director, the petitioner had no role to play. By the time the crime was detected, the crime was committed, he was no longer connected with the company.
Yes.
And subsequently, his name came into the FIR. My lord will take the FIR. It is written in Bengali. My lord is sufficiently conversant with Hindi. He comes with Bengali, my lord. Staying too so long in Bengal. My lord, the gist is that one Kamendra Bormon, he had in the month of December 2009, he had went to Alipurdwar. This company made with the company New Land Agro Industries Limited, and he had made a deposit.
on 19 to 2011.
Yes.
On 2013, when he went to, he's found that he was not getting his returns back in the year 2013. Then he detected that the new land agro is no longer in existence, it has closed down. So whatever happened till 2013, he received the money from the company. So nothing was wrong up to 2013. And I have shown to your lordship that the petitioner had resigned in the year 2011. So even after the petitioner stopped looking after the affair of the company was running good and there was no offense created till that day.
You are on bail.
Yes, madam.
You have been granted bail. Whether 41 was issued to you.
My lord, 41.
And this, the resignation and all these things have been produced before the investigating officer during the investigation.
But I am not aware of that, but probably
No,
not.
Lordship, the resignation not collected, not deposited, they have deposited it, that's all.
Your deposit.
No, they have.
They are deposited in the application.
Application, that's all.
But during investigation.
It was not seen.
Lordship, this is page 23, that is a form 32, the companies, they have downloaded the same and deposited.
Bringing out in all means and purpose, when the offense started perpetuating, I was no longer.
Yes.
And so the petition has come back to the honorable court praying for watching the case against him.
Page 25 is the relevant portion, where we find that some resignation letter from PK Dash PDF is there, but we cannot say because it was not given to us.
Then the investigative officer may very well collect it now.
Investigation completed. Charge sheet filed.
Yes, ma'am.
So how this document be taken into consideration under this proceeding?
Before this court, madam. Madam, this was available all through in the office of the accused company.
That's
The
correct.
investigating officer missed out certain documents. Still now, they can bring it as a supplementary charge sheet.
But this court, you have come under 482.
Lordship.
482, this is the main ground.
Lordship.
With regard to you are not.
Another limb, this is one limb of an argument, and another is 420 and 400
That is
incompatible.
That is a different thing. And that if then, and with regard to this, how far this court can believe that taken into consideration of that document?
But it is from the official record of the registered company.
Maybe.
This is a third-party document because we are not collecting.
No, but it's a criminal procedure.
Right.
This is a
But
procedure
actually,
and
what my lord indicates
under
very indirectly that I should have gone before the court below and filed a discharge application, come up against that. But I totally understand. But I was banking on 420, 406 incompatibility. But I'm apprehending that, as I know your lordship to be, your lordship will show me that work there. This matter I do feel, but matter ultimately let us assume that I have done before the trial court. Trial court will, with a closed shut eye, refuse me. That we know matter. Only a prolongation of the matter. And that would be an abuse of court. If it is not till now, it will be there. And matter actually it has been demonstrated with one difficulty there with the pinch of salt, the documents can be looked into. There is no case against the case.
that is correct. Yes.
May I hand over the case diary?
My lord, there is one mention in the charge sheet. My learned friend of the prosecution may be able to throw light. During investigation of this case, report had been called from the Reserve Bank of India. My lord, final page 19.
I'll show that on those documents.
Yeah.
Is my lord on?
Which one?
My lord, page 19, first, second, third paragraph.
90.
190.
Yes.
During investigation of this case, a report has been collected from Reserve Bank of India, Securities and Exchange Board of India, which stated that the company Newland Agro Limited is not a registered company. Further, also collected report from the Registrar of Companies along with details list of Board of Directors of Newland Agro Industries.
Yes.
So this resignation document should be with the prosecutor. Because
The
the
list of
ROC has sent me
directors
the
as
report.
per the superior verification. So, in your CD, where is that report?
Lordship. First, kindly Lordship sees page 82 to 84. That is a letter to RBI and SEBI.
Yes, it is IO letter.
Yes, Lordship. Then Lordship kindly sees page 113. Letter to the Director, Register of Companies. And 120, another letter. Now relevant portion is Lordship 148, page 48, where reply is there.
Page
148. Along with the reply, they have given a photocopy of the register, where the name of this petitioner is there, Pinku Kumar Das, from 2010 to 2000. Lordship kindly sees that
page 148.
148, and then next two pages, the copies are there. Then his name appears, Lordship, Pinku Kumar Das, maybe on this or on the
7.
Pinku Kumar Das.
Lordship. There are two,
Pinku
one
Kumar.
one as the additional and one as the director. Now see the tenure.
2010, 2010.
He was the additional director, and then 2011 he was the director.
Additional director.
Uh,
Where is the director?
Lordship, just below that, below or above.
Lordship 7, Pinku Kumar Das, is in brackets model, right? Director / additional director. From
No, it's not that.
No,
I'm
it is not
referring to the original copies. I'm not referring to that. The copies of the register. What is Lordship? There are two paragraphs. Pinku Kumar Das, there are two paragraphs.
Acha, director 2011 to 110 2011 and assistant director 2112 to 2012. 1 year.
So he was the additional director and director of the company till that. The involvement of this petitioner is here.
And what is where is that time of the alleged offense? Period of the alleged offense?
27/11/2014 FIR was lodged.
No, FIR was lodged. What is the main complaint? Which period to which period he has deposited the amount?
He received it till March, the month of year of 2013.
Lordship, page 15 of their petition is the FIR. 1, 2, 3, 4, 5, 6th line. সেখানে আমি আমার নিজস্ব টাকা 19 to 2011 থেকে গচ্ছিত রাখছিলাম। গত 2013 ইংরেজি মাস হইতে গচ্ছিত টাকা প্রতিশ্রুতি মতো ফেরত পাইতেছি না। So since 2013 he is not getting back.
There is no problem.
So
after that.
As per the FIR.
So if after that, then he was not there.
Because the statements are there, Lordship, 87 to 89, the investor statements, name of other directors are there, but
87 to
89, Lordship. Localite near the companies, and Lordship, kindly see from first page 30 to 39. Page 30 to 33, then 38 and 39.
32 is the evidence witness.
30 to 33.
30, 33.
Then Lordship 38, 39.
Yes.
38, 39. Then Lordship will find
48,
39. Then Lordship, 87, 89.
38, 39 is the Alipurduar police station. What is this?
Lordship, as per my, this is 161 statements.
38,
Oh, 38, 39,
38, 39, something,
something.
some other.
Lordship, maybe 1 to page Z. Lordship, I marked from the original city and subsequently it has been sent and this is the
Then 79,
Lordship. 87, 89, Lordship, maybe from my
79, 80.
7, 80. 87,
So
89.
these are the evidence.
These are evidence,
These
but
are witness.
Lordship, admittedly, his name is not
Not
mentioned.
there.
Lordship may look into it. But his involvement, the company's document.
He was
the
director, he was director
and
and
additional
assistant
director.
director, 2010 and 2011. And this,
But his resignation document is not there.
he has paid the money to the company in the year 2011 itself.
Lordship, as per the FIR.
As per the FIR, and he got the benefit from the company 2013.
It is mentioned from 2013 মার্চ হইতে টাকা প্রতিশ্রুতি মতো ফেরত পাইতেছি না।
ওই তো 2030 onwards he felt
He is not getting as per the FIR,
and he had deposited on 19/2/2011.
2011. At that juncture he was in the company.
2000?
February 26, 2013, he resigned.
But our submission not some money
So no, I was there, he was getting returned.
So he has taken the amount and left. But it is not the case made out by the police. So appearing for the petitioner, so appearing for the state. The petitioner has filed the present application praying for quashing of the proceeding in connection with Alipurduar police case number 416 of 2014, dated 27/11/2014. 2014 under section 406, 420, 34 of the IPC corresponding to GR case number 3149 of 2014, pending before the London Additional Chief Judicial Magistrate from Alipurduar Police. Counsel for the petition submitted on the basis of the written complaint dated 27/11, written complaint dated 27/11/2014, the police of PS Alipurduar has registered the above case for the alleged offence. And after completion of the investigation, the police has submitted the charge sheet, being charge sheet number 421 of 2018, dated 3rd September 2018 for the offence under section 420/406/34 of the IPC. Police. Counsel for the petition submitted that though the complaint is not against the company, but the police has initiated the case against all the directors of the company. It is also alleged that the petitioner, being one of the director of the company, is involved in the matter, and accordingly the charge sheet has been filed. Police counsel for the petition submits that as per the complaint, the petitioner has deposited the amount in the company, namely
New Land Industries Limited.
Company, namely New Land Agro Industries Limited. And after the deposit of the said amount, the complainant was getting the benefit of the said amount from the company till the year 2013. And subsequently, the petitioner could not get the benefit of the amount deposited with the New Land Agro Industries Limited. Accordingly, the petitioner and the complainant has made the complaint before the police authority. It is the specific case of the complainant, it is the specific case of the petitioner that though the petitioner was the director only till the year 2011, and thereafter he has in the year 2013, and when he resigned, and on page
Kindly you sign, but kindly in the one, fourth paragraph, item number 7. Roman 7. Ipu Kumar Rao.
And he resigned from the said company on 26th of February 2013. He submitted that it is the specific case of the complainant that till the year 2013 he got the benefit from the company, and thus the petitioner is no way involved in the incident case. But the petitioner was the director of the company. According, the police has filed the charge sheet. Police has filed the charge sheet. I am not taking into that two section, otherwise other case process will be. They will get the clue. Police stop. The Leonard police counsel for the petitioner further submit that though the police has not seized the document from the petitioner, and though the petitioner has informed the police that he was not the director at the earliest point of time, but in spite of having the knowledge, the police has submitted the charge sheet against the petitioner, though the petitioner has no way connected with the alleged offense during the said period. Full stop. The Learned Counsel for the state has raised objection and submitted that this is the case under section 406 and 420 of the IPC, and after the receipt of the complaint, police has initiated an FIR and thoroughly and has investigated the matter and had collected several documents wherein it is categorically proved that the petitioner is also involved in the matter. And in the proceeding under section 482 of the CRPC, this court cannot go into the deeper fact of the matter whether the petitioner is involved or not. It is submitted that from the prima facie it is proved that the petitioner was the director from 2010 to 2013, and the incident was occurred in between. Thus, the petitioner is also involved in the matter. Accordingly, during the investigation, the police has filed sufficient material against the petitioner and filed the charge sheet. He submits that if the petitioner relied upon any document, he can take the benefit during the examination of the witness during trial. He prayed for dismissal of the application. And if any further objection is required to. Had the Learned Counsel for the respective parties peruse the materials on record. This could find that the specific case made out by the petitioner in the present application that though the petitioner was the director or assistant director from 2010 to 2013, but in the month of February 2013, the petitioner has resigned from the office and the resignation of the petitioner was accepted, which is also reflected in the charge sheet. The counsel for the petition submit that it is that case of the complainant that the complainant had deposited the amount in the month of February 2011, and the month on 19th February 2011, and he got the benefit of the said amount from the company till the year 2013. So it is proved that till 2013, when the petitioner was director or assistant director of the company, the complainant was getting the benefit. Subsequently, the petitioner has resigned from the said company on 26th of February 2013. Thus, it cannot be said that the petitioner is involved with regard to the instant offense. Full stop. The prosecution has the Learned Counsel appearing for the state has produced the case diary, and this could find that during the investigation, the investigating officer has received the document from the registrar of company, wherein also it reveals that the petitioner was the director was initially assistant director from 31st of assistant director from 2012-2010, was additional director with effect from 2012-2010, and subsequently he was the director of 1st October 2011. 2011. From the investigation, from the report of the from the charge sheet, it reveals that it is admitted case of the prosecution that on 29th of February 2013, the petitioner has resigned from the said company and the resignation of the petitioner has been accepted. If it is the case of the de facto complainant that the de facto complainant has received the benefit up till the year 2013 and thereafter the petitioner could not get the benefit and the complainant could not get the benefit of the amount deposited in the company. But at that point of time, the petitioner was not the director or assistant director of the company, as he has resigned from the said company in the month of February 2013. Considering the above fact, this court find that there is no case made out against the petitioner for either for the offence under section 420 or under section 406 of the IPC. Considering the above, this court find that this is the fit case wherein the proceeding of Alipurdwar Police Station case number 416 of 2014 dated 27/11/2014 under section 406/420/34 of the IPC corresponding to GR case number 3149 of 2014 pending before the additional Chief Judicial Magistrate Alipurdwar is set aside and paused with respect of the allegation against the petitioner. The petitioner is discharged from the instant case.
Can you consider that the tenure as per the charge sheet at page 19 is 2012-2010 to 26-2030? That tenure we have got. But whether he has resigned or not, no document to that effect.
Okay, ऊपर एक लेटर देख लेना, ऊपर जो है ना prosecution का. The learned counsel for the state submits that though it is mentioned that he was in the company till 26 February 2013, but there is no document that whether he is resigned or not.
Petitioner, Lord has heard this matter on last occasion, day before yesterday.
Which one?
Lord, maintenance matter, Lord, 4,000 initially maintenance granted,
Hmm.
and thereafter, Lord, 127 application preferred by my wife. Lord, the maintenance amount was enhanced to 10,000 rupees. Lord, interim order was there, Lord, that I'll be paying 8,000 rupees to disposal. And Lord, even there was a prayer of 8,000 only. So, Lord, my
Yes.
My lord, the entire case is based upon that, my lord, the petitioner being the wife have
No,
claimed.
that's correct.
My lord, let me, my lord. So how can we know, my lord? I have to see the prayer. My lord, kindly see the prayer once, my lord. Kindly comes to my 127 application.
Where is that?
My lord, after the judgment, it is not paginated. Kindly see.
Your application?
127. Yes, my lord, 127 application. My lord, get the judgment, my lord.
Yes.
After the judgment, my lord, the 127 application. Miss case number 11 of 2021.
Yes, please.
Yes, my lord. Kindly see the prayer once. Accordingly, it is paid that after considering the above mentioned, DD honor would be enough to increase the said maintenance allowance to director opposite party number to maintenance allowance to rate of the 10,000 per month, my lord. Then, my lord. Then, my lord, come to the judgment, my lord. Why, my lord, 10,000?
You have prayed for 10,000.
Yes, my lord.
Yes.
Thereafter, my lord, page 7 of the judgment, my lord. Page 7 of the judgment. My lord, it is might be page 6, my lord, before the order.
The judgment contains 6 pages out of the 7.
No, my lord, 5 pages then, my lord. It is written in 7, my lord.
Huh?
Page 5 of the judgment, my lord.
Yes, which paragraph?
My lord, paragraph number 1, 2. My lord, paragraph number 2, last portion, my lord.
Yes.
My lord, the petitioner has been showed that his income is his deduction is 37,800. This is clear the depicts that the OP has more expense than his income, and thus this court can clearly presume that the OP is deliberately tried to misguide this court regarding his actual income.
Correct.
My lord, this order has been passed when his income was below 40,000. At that time, 10,000 was passed. At present, my lord, his income is 46,000. So, my
Now
lord,
what amount has been awarded?
my lord, 10,000, which I have been paid for.
4,000 to 10,000.
Yes, my lord.
Yes.
10,000 I have paid and 10,000 is allowed. Upon 40,000. At present, his income is 46,000.
What you are doing?
Lord, I am a constable in West Bengal.
And what the wife is doing?
My lord, I have no.
Housewife.
Housewife.
How many children? There are no children.
Lord, one thing, Lord, which I proposed to my learned friend on the last occasion, that Lord, for the last 14 years, Lord, we are residing separately. Lord, the marriage has irretrievably broken down.
Correct.
Lord, I proposed.
When
Lord,
the marriage was solemnized?
Lord, 2009.
2000.
And 2011, Lord.
When he left?
2011.
2011.
Yes. Now, Lord, on the instructions of my client, Lord, I have proposed that if, Lord, in our level, Lord, if this can be settled outside court, so, Lord, ultimately the litigation can.
So you are residing in 2011 separately.
My lord, so
Correct.
for
Now
my,
we are on 25.
my lord.
So why you are not settling?
My lord, I have asked her, my lord, she did not reply me.
Why?
I don't
Take
know.
the permanent alimony.
Client is present.
Is the government saying take the permanent alimony?
Yes.
My lord, I will talk, let it be in pending. Until then, my lord, let the 10,000 stay be vacated. My lord, 10,000 be allowed. My lord, let the matter be pending. I will talk with her, my lord.
Take the go for the permanent alimony. Go for the 13B filed, and
Yes.
I will let
and
the.
all the matter can be settled once more, because you are not having the
No,
child,
I have no man,
not having any issue.
Right.
So if there is no issue, what is your wife's age?
My lord, almost 40 to 45, my lord.
So take that.
My lord, I will converse with her. My lord, let it be the stay be vacated. Let the 10,000 be paid till that, and my lord, thereafter, my lord.
There is a stay, my Lord.
Have you married second time?
Yes, my lord. My lord, my lord, I have a proof.
Okay, I have
Birth
going into
certificate.
that. Going into that.
I have, my lord. And my lord, his
You have
actual.
not filed the matrimonial suit.
Lord, I filed, Lord, I lost. I preferred an appeal. Appeal is pending before the Honorable High Court. Lord, litigations after litigations, Lord, that is not going to help any of
Whether
the.
mediation conducted. Matrimonial suit, no mediation was
No
conducted.
mediation conducted.
Which court?
Alipurdwar, Lord. Alipurdwar. Lord, now there is no scope of reconciliation.
No. See, it is not the consideration, it is not the meaning the consideration to reside together.
Lord,
Consideration
Lord.
means that what is
Permanent allegation.
nowadays the same thing is going.
Lord.
It is now, okay, give the permanent alimony,
Yes.
because see,
Yes.
tell your client,
Lord.
if 10,000, so yearly
1,20,000.
1,20,000, 1,20,000, then you have to pay continuously, we don't know, and subsequently again enhancement.
Lordship.
Now the again pay commission will come, again it will be enhanced.
Lord.
Correct.
Lord.
So it will be to set together, tell your client, give some handsome amount and finish it off.
Lord, he is willing.
My lord, I
He is
will.
willing.
My lord, I will
Tell
take
your
the,
client.
I will, my
Lord,
lord.
let there be an order to that effect.
Whether you are paying, no, I cannot pass the order.
Lord, at least for a mediation to that effect, Lord, because I am willing.
Your mediation is ready.
My lord, I have to take instruction, but until then the stay may be vacated, my lord. Because my lord,
You are paying the amount.
I am paying the
my lord, yes, 8,000 I am getting. There is no, my lord, discrepancy. 8,000 I am getting. My lord, but the stay kindly be vacated, because stay is granted on the ground that the petitioner has been claimed 8,000, and my lord, it is increased to 10,000. My lord, now it is crystal clear that I have been paid 10,000. That is why the 10,000 is allowed, on the ground that he has been misguided the learned court
Okay,
below.
do one thing.
My
I
lord.
am keeping the matter on Wednesday.
My
You
lord.
take your client advice.
My
You inform your client.
My
Where she reside? Here only.
My lord, Alipurdwar.
Alipurdwar. You call your client, take the advice and inform your client.
As your lord.
And what she want the permanent alimony, inform your client. If it done
I
so,
will.
then I will pass a prepared order to
As
that
your
effect.
lord.
Correct?
Lord.
Let the
Gratefully.
fix 20. 20 तारीख.
Gratefully.
Grateful.
My lords, I am for the petitioner. My
With
lords,
21 को ना Wednesday 21. Yes.
My lords, on the last occasion, day before yesterday, my lords had heard it again. 306 portion.
Yes.
My lords, may I be allowed to place the judgments?
Yes, you have gone through the CD.
My lord, I have gone through the CD.
Yes, there is any materials.
Materials in the sense, my lord, what on the last occasion my lord has seen regarding the 161 statements and the FIR. Now, my lord, in support of my case, I'll be citing one citation.
The citation I will come if you, I will.
CD, my lord.
What are the materials you are relying upon?
बाप रे, हमारे तो नहीं बहुत खर्चा कर लिया.
What are the materials you are relying
My lord,
upon?
these are in page number 789, my lord, where the name of this petitioner came, my lord. And the deed of lease 7, 8 and 9. And 161 of the page number 6 of the complainant, my lord. Now, in a similar type of case, my lord.
Page number 7, 8, 9
of the CD.
Yes.
6, 7, 8, 9.
6, 7, 8, 9. Then
And deed of lease is page number 23.
23.
My lord.
Yes.
Just to refresh my lord's memory, my lord, the thing is that this is a case regarding 306, my lord, abatement to commit suicide, where in a resort in nearby Siliguri, a poker game was going on, illegal poker game was going on, and people used to come from Sikkim and other parts of the country.
Correct.
They used to play here, and they were served with food, liquor, room, as well as from the room, several used condoms were found. So there was a free access of the girls also. So now thing is that after that, he played their poker, he lost there, and thereafter, this gentleman, Mr. Petitioner, he has paid him as per the version of the wife of the deceased. He has paid him 35 lakhs. There was a constant pressure to pay that amount back, and which he failed to pay. Then he called his wife, and his wife also refused to pay, and automatically he has no other ways because he was in the room. He was not allowed to come out to the room, and he thereafter committed suicide. Now, at the very first stage, his wife was informed. The body was recovered. The body was, UD case was started.
When
There was
35 lakh was called, was demanded.
that was demanded through telephone. It was informed.
When? What is the date? And by which telephone number, when, to whom it was called?
My lord, it's in the FIR, my lord.
Yes.
Page 2.
Yes.
I the undersigned to Tanjing, the resident of, do have investigate the date of the circumstances surrounding the death of my husband, who passed away on 22nd February 2023 at Blue Mountain Resort, Siliguri, where they an illegal poker place named Country Poker Place. It was a separate, the premises was leased and it was named as Country Poker Place.
Correct.
The place is run by one person, Dasho, matlab the nickname of this petitioner, or Tashi, from Bhutan, along with one Rahul Gupta and some other persons. On 22nd February, we came to know that my husband, this is the incident on 22nd February 23, he came to know that my husband is that place playing poker on a from Dasho on a invitation from Dasho. That means this Kajo. The details can be recovered from his call or message records, following which call up Dasho, he did not answer the call. After which I spoke to Rahul Gupta and told me that my husband is not well, and he has that Tenzing is there at the place and played poker on given Dasho and lost 35 lakhs. I clearly told him that we are not in a position to pay the money and that the institution run by them is illegal, and any intoxicated medicines once then is Rahul Dasho will be responsible for this, my lord. This is the actual allegation against them.
Where is the CDR? Have you taken the CDO?
My lord, I had a talk with the IO.
the CDRs could not be collected, my lord. Because the phone was missing, my lord.
Which?
The phone of the deceased
One of the deceased.
was missing, my lord. That's why it could not be. Now, police, it's a non-cognizable case. The police has started, a UD case was started after the complaint, after a few days when the complaint was lost. Because there was a doubt in the mind of because later she came to know there was a doubt. And thereafter, she filed the case and specific case was started under section 306. After investigation, one person was arrested. This petitioner was absconding for a long time. Thereafter, he preferred an application for anticipatory bail, which was later granted. Now, after getting the anticipatory bail, he has come with an application for quashing of this case. Now, thing is that in a similar circumstances, my lord, in 2011, Delhi High Court of Delhi, the thing is that two things are there. It's a 482 of case in a 306 case. It's a 482 petition where there are some certain guidelines of the Supreme Court which has to be followed. That is one issue, my lord. And as it's a wide discretionary power of the court, so it has to be used sparingly, my lord. Everything has to be taken into consideration. Now, case varies from cases to cases. So, as per here also what happened, a person committed suicide, and after he committed suicide, certain papers were found, 2-3 pieces of papers, stone papers. From that, it could come to a conclusion, it is a suicide one. But the court has not gone to that. What after the suicide was there, the person whose name was there, they paid compensation to the family members, the complainant, and they have given that no objection also. But even then, the court hold that no, in a case of suicide abatement to commit suicide, certain things has to be taken into consideration. While in this case, I'll be referring, my lord, paragraph 15, 16, 17, I'll be giving you this copy here from the state. Paper, not to destroy papers. Don't waste papers.
Yes.
Now, here the findings of the court was that paragraph 15, the concept of abatement.
Paragraph
15, my lord.
Yes.
The concept of abatement to suicide is dealt with under section 306 IPC. Now, the definition is there. Second is 107. Abatement of a thing. A person abates the doing of a thing who first instigates any person to do that thing. Secondly, engages with one or more of that person or persons in any conspiracy for the doing of that thing. If an act or illegal omission takes place in persons of the conspiracy and in order to doing of that thing. And thirdly, intentionally aids by an act of illegal omission the doing of that thing. Explanation to how whoever either prior to or at that time of commission of the act does anything in order to facilitate the commission of the act and thereby facilitates the commission of thereof is said to do an act of that act. And in case of Rakesh Kumar versus State of Chhattisgarh, here the word instigation has been defined. Instigation is a goad, urge, forward, provoke, incite, or encourage. So, my lord, instigation doesn't mean, though the section says there must be a specific provocation, but the word instigation has a wide definition. Here, what are the words? First is goad, urge, forward, provoke. So, as per the FIR, if my lord goes through the FIR, there is an allegation of provocation. He was called, he was invited for that from Sikkim to come down to Siliguri to West Bengal and to play poker. So here, provocation, incite or encourage. If you are encouraging something illegal, it's not that nowhere it is legal that this poker, because police has shut down, police has started specific cases, police has shut down that property. Now the property is closed. So here there was an illegal poker game going on. Well, people from outside were coming. They were being provoked. They were encouraged to play, and ultimately this resulted to the demise of this deceased, and he committed suicide because he's back stuck in the wall. He has no other alternative. That's he taking the decision to commit a suicide.
Yes.
And another thing is that, and so there, my lord, the quashing application, though the complainant has given NOC, they got the compensation. Even the court come to a conclusion that this is not a case of quashing at this stage without going to the trial of the case, because it creates a bad impact on the society. It becomes a precedent.
Yes. Yes,
My
next.
lord, this is my case, my lord. So humbly pray at this stage, this cannot be coerced, my lord, until and unless trial is there and without going through the evidence of the case.
Okay.
My lords,
Yes.
my lords, on last occasion, I had taken you to the FIR as well as the 161 statements of the accused person. 161 statements of the witnesses.
Yes.
My lords, may I take you once again through it? My lords, the FIR is at page 38. My lords, in a nutshell, what the FIR says is that my lords, the paragraph, my lords, page 38 is a typed copy.
Yes.
The paragraph 2, my lords. The place is run by one Dasho along with Rahul Gupta, petition number 1 and petition number 2, and some other partner. On 22nd February 23, I came to know that my husband is at that place playing poker. On the invitation from Dasho, the details can be received from his call and message records. My lords, no CDR, no messages. My lords, even if the phone is lost, CDRs can still be found. My lords knows it better than me. If following which I called up Dashu, but he did not answer the call. After which I spoke to Rahul Gupta and told him that my husband is not well. He informed me that Tenzing is there at the place. My lords, as per the complainant, it's petition number 2 who had informed her that the person has lost some money, and he was. I clearly told him that we are not in a position to pay the money and that the institution run by them is illegal, and if any untoward incident occurred, then he, Rahul Dashu, will be responsible, as Tenzing suffers from depression. My lord, he had a pre-history of depression as well, as said by his wife. There's no mention of any pressure in this paragraph when she allegedly spoke to the petition number 2. My husband was to return that very day. He had informed his mother at 11:30 a.m. in the morning. I spoke to Rahul Gupta around 6 to 7 p.m. in the evening, but the same night at 2 a.m. when I called my husband, a police person answered his phone and informed me that he was found dead in his hotel room. Well, nowhere here she has herself spoken to her husband at any point. He has informed me that
No, my husband was sure to return that very day and had informed at AM in the
mother,
morning.
my lords,
I spoke to Rahul around 6-7 p.m.
in the evening.
In the evening, but the same night 2 a.m. when I called my husband, a police person answered his phone, informed me that he was dead.
So,
yes,
my lords, no communication that he was detained. His wife, they asked his wife for money. Nothing of this has come from the complainant herself. There's no such allegation. And my lord, there's a prehistory of depression that her wife is telling. I request you to kindly look into the matter, as I strongly believe. My lord, only on a belief she has lodged this complaint. There's nothing else.
Yes.
That after the phone call to Rahul Gupta, they must have pressurized. The submission of my learned senior over here that they have called the wife and pressured her to also pay the money. Nothing has comes from the transpires from the complainant that they must have. She is not sure if they had or not.
Yes.
They must have pressurized him regarding the money which had abated to Tenzing committing such act. Also, Rahul Gupta had my phone number via which he could have called me, but neither did they. That's it. My lords. My lords. Then may I bring you to the chart sheet,
Yes.
the seizure of the chart
Yes.
sheet. My lords, will come page number 46, my lords.
Yes.
Second column, my lords. My lord, the first has various documents. They have not made the hotel persons any accused person. Nobody from the hotel management team, hotel owners, nobody has been made an accused. Second paragraph, my lords, they have see some CCTV footage. My lords, one has to. CCTV footage seized by them is from 18/3/23 dated.
Where from you?
2/23 to 3/20/20. My lord, the incident was for my lord, item number third line, my lords. Second column, third line of the property description.
Deed so and so.
Next paragraph, my lords. Next column.
One Xerox copy of the notary register. One original copy of the notary register. One Xerox copy of.
Not this
one. Black color SanDisk pen drive having series number so and so containing CCTV footage. CCTV footage of blue mountain country Resort 18th March 2023.
My lord, the incident is of 22nd February 2023, my lords. I do not know how they will prove any case through such CCTV footage. And my lords, they have been saying constantly that
Incident of 22nd February.
22nd February 2023. 22nd February 2023, my lords. They have collected footages from 18th March 20, after the date of incident, way 1 month after the incident.
Yes.
My lords, if any untoward incident also has happened, one will never be able to find out. It's very sad. My lords, thirdly, they have been again and again saying that poker game was happening, girls had come, so many things are happening. One girl is not even a part of this 306.
Okay.
Secondly, my lord, if poker game was happening, my lord, they have not even seized a single poker chip from anywhere in the hotel resort. Any cash, no poker chip, nothing at all, my lords. How are they going to prove that a poker game is going on? One poker chip also has not been seized, my lords. No cash amount, no poker chip, nothing. One of the accused person was also in jail custody for 27 days, my lords.
How many accused persons remain?
2 persons, my lords. One was arrested and was.
He has also granted bail.
Yes, my lord. After 27
What is his
days,
name? Who was arrested?
Rahul Gupta. Petition number 2.
Both are here.
Yes, my lord. Both are
Okay.
here.
Yes.
My lord, this was my lords. Then, my lords, let me take you to the 161 statements, my lords. One is the complainant, 3 are the friends of the complainant, and 2 are the hotel people. My lords, I had also given you a translated copy.
So his body was found lying in the
It's
floor.
from the inquest report, my lords, it seems so.
So who has
My
brought
lord,
the body down?
My lords,
Because it is the case of suicide by hanging.
Statement of the hotel workers, my lord. It was opened by the manager with the master key.
Where is that?
That's where.
statement of the hotel. 67, my lord. 67 and
This room was allotted to him only. No, this room he allotted to him.
I will take page number 20 of the CS.
My lord, it's in my petition as well. 67.
67.
67 and 68 are the hotel persons.
17 of the
17. Okay, I will come. Yes. Yes, I will see.
My lord, statement.
I will see.
My lord, my 161 statement of the complainant first.
Where is that?
63, my lords. Page number 63.
Yes, he has only stated this. He received the nothing else.
He has a doubt. Her husband was unwell.
Correct.
This is what happened, that he was staying in room number 113. After 10 days of this incident, she had made a complaint. Before that, she did not come before. Same thing on a hearsay, they have heard, his friends have said that they heard from his wife that the deceased.
Where they were playing the poker.
Mala, it is alleged that at a hotel resort.
Hotel resort, which portion it is?
Mala, this is not mentioned anywhere in the charge sheet or the FIR or anywhere else. Nothing is there. And
who are the other persons? Is there any?
My lord, this they have to investigate. I am not the investigating person.
These are the two persons.
Two people.
And other? There is no other.
There are 2 persons.
Only
who
2
are staying
persons.
in the property place. One in the name of the, I think, mother of Rahul.
No, that's correct. That's correct.
My lord, it is an incorrect statement.
After the incident happened.
It is incorrect statement.
No, see, all fled away.
Close the
This is the hotel. And this
portion of the hotel.
portion, correct. The portion of the hotel, the poker was playing in the hotel premises only. Correct. If it is playing in the hotel premises and you have taken the CCTV footage. You have taken the CCTV footage, who have entered, who had played the poker, who are along in the poker.
Served a notice by page number 17 under section 91 of the CRPC.
To whom?
To supply us, to the hotel authority. To supply us the CCTV footage from 18th February to 23rd February. The incident occurred at that time. They have not supplied us.
So you are not entangled them. 201, you are not involved.
Instead of that, what they have done, they have supplied us after the incident, that we are not in such type of business and there is no such business for poker. So already everything was shifted from there. They are asking that no poker coin, no poker cards was how? Because after the incident, everybody fled away from there. The room was closed, the entire the furniture and fixtures were removed from there. And again, it came to the owner has done everything in connivance with this person.
My lords, on the
Now
very,
the specific, if had it been there had been no implications of this petitioner, they would have not closed the poker game. They would have run it. Because after the incident, they have closed it.
Okay.
my lords, on the very same day at 2 a.m., the police persons were already at the hotel resort. It's not the case that they did not do any action. They could have investigated at the very a UD case was started immediately, my lords. A UD case, it was open to the police officers to do it. My lord, let me.
Face of it, come to a conclusion. And
my
only
lord,
that the defective complaint has not appeared is because after she is suffering from trauma, after this incident, she has left from its place.
my lord, the petitioners also cannot be pulled into any case, any criminal case without on the basis of any mere doubts. For 2 years, they have also been suffering. One person was in custody as well.
You are in answerability value. Face the trial. It's not that.
But my lord, let me come to the judgments, my lords. My lord, let me place a citation. What purpose will be solved by this conducting such a trial? Just misuse of the time of the courts. Misuse and abuse of the process of the court. My lords, may I come to the judgments now?
Yes.
Grateful, my lords. My lord, the first is a recent judgment of the Supreme Court, which my lords was referring to, I believe.
Yes.
My lords, I have marked 1, 2, 3. My lords, at paragraph number 14. First judgment, my lords. This is dated April 30, 2025.
Yes.
My lord, paragraph 14 to 20, 14 minutes.
Yes.
What turns are primarily from the sequence of event statements and the suicide note is that from 11, this is until the actual date of suicide, there has been no contact whatsoever, either in person or by phone or any other means, whatsoever, either in person or by phone or any other means between the deceased and his relatives and his wife or any other accused, which would indicate continuous harassment or torture or any sort of pressure at the hands of the accused appellants on the deceased. My lord, they have not brought harm. Therefore, there is no proximity of any harassment or instigation prior to the incident of suicide having taken place. Otherwise, also which can be said to have led the deceased to commit suicide, leaving him no option but to push the deceased into a position that he committed suicide. My lord, it is very important that there has to be no other option left to the accused to the deceased other than committing suicide.
Yes.
From the suicide note, no abatement can be said to have been established that the accused instigated the disease or there have been any persistent cruelty or harassment which would make out an offense of abatement or suicide. Merely on the basis of the allegations of harassment and that to a month ago, which in between there being no contact or any sort on the part of the appellant till the time of occurrence, which can be said to have led to or compelled the deceased to have committed suicide, the offense has not been made out. Mens rea cannot be presumed, but must be ostensibly present and visible, which is missing in the present case. It involves a mental process of instigating a person and without a positive act on the part of the appellants, which can be said to either to instigate or aid in committing suicide, the ingredients of the offense cannot be said to have been present. Section 306 requires a person having committed suicide as a first requirement, but for abatement of such commission, which is essential, the ingredients must be found in Section 107 IPC. The requirement of abatement under Section 107 IPC is instigation. Secondly, engagement by himself or other person in any conspiracy for doing such thing or act, or a legal omission in pursuance to that conspiracy. And thirdly, intentionally aids by any act or illegal omission of doing that thing. In large number of judgments of this court, it stands established that the essential ingredients of the offense under Section 306 IPC are the abatement, intention of the accused to aid and instigate or abate the deceased to commit suicide, merely because the act of an accused is highly insulting to the deceased by using abusive language would not by itself constitute abatement of suicide. There should be evidence suggesting that the accused intended by such act to instigate the deceased to commit suicide. My lords, before going further into my lords, if we assume also that a poker game was going on that day, and this person's actually harassed these guys to give them, what will they get by asking him to commit suicide?
Yes.
Will they recover the money? No. And secondly, my lords, even if poker game was going on, how is it implicating this person's?
Okay.
Similarly, in the case of Uday Singh versus State of Haryana, it has been observed in para 16 as follows. In cases of alleged abatement of suicide, there must be a proof of direct or indirect act of incitement to the commission of a suicide.
Yes.
It could hardly be disputed that the question of cause of a suicide, particularly in the context of an offense of abatement of suicide, remains a vexed one, involving multifaceted and complex attributes of human behavior and responses reactions. In the case of accusation of abatement of suicide, the court would be looking for cogent and convincing proof of the acts of incitement to the commission of suicide. In the case of suicide, mere allegation of harassment of the deceased by another person would not suffice unless there be such an action on the part of the accused
Okay.
which compels the person.
What is the next judgment?
Before it goes to the next judgment.
My lord, I have also marked the paragraphs. Second,
The case.
my lord, let me,
Okay,
my lord, let me
let's-
complete, then my senior can,
Of the wife. The in-laws of the husband.
my lord, may I complete?
Let me complete you. Let he complete. Let me see
I did not
complete.
get a chance to even complete my.
Let's see
submission
complete.
once.
Let's
Before that, you have
No,
a.
we have a 332, that's why.
No. I am sure my laws will accommodate us for some time.
Yes.
My lord, second is paragraph number 12 to 15, the second judgment. This is also 2020. My lord, I'm relying upon the principles that has been laid out in all of these judgments and not just the facts. Paragraph 12, my lords, the second judgment on this. If the version of the appellant complainant is to be accepted, the question remains as to why she kept silent from 14th April till 22nd May 2024. If her husband was upset a week before his death, whenever he received calls from respondent number 23, he was blackmailed by the said respondent, nothing could prevent the appellant complainant from reporting this matter to the police immediately after the deceased committed the suicide. Thus, it is apparent from the material record that all these allegations were an afterthought. Assuming that allegations are true, even otherwise, the case under section 306 IPC would not be made out. Recently, this court in this case,
Yes.
my lord, in case of Sanjay Singh's, my lord, after paragraph 13, the judge citation. In the case of Sanju Singh, this court, under similar circumstances, had quashed a charge sheet under section 306 of the IPC against the accused appellant. A factor that had weighed with the court in the said case was that there was a time gap of 48 hours being the alleged instigation and the commission of suicide. This court held that the deceased was a victim of the own conduct, unconnected with the quarrel that had ensued between them and the appellant 48 hours prior to the commission of the suicide. In the case at hand, taking the allegation that by the incident occurred on 17 February 20, while the deceased had committed suicide on 28 March 2015. There's a clear gap of over a month between. We therefore find that the court will have erroneously accepted the prosecution story that the act of suicide by the deceased was a direct result of the words uttered by the appellants at the Mahal court. The cardinal principle of the subject matter at hand is that there must be close proximity between the positive act of instigation by the accused person and the commission of suicide by the victim. There has to be a positive act. The close proximity should be such that as to create a clear nexus between the act of instigation and the act of suicide. As was held in the case of Sanjay, if the deceased had taken the words of the appellant seriously, a time gap between the two incidents would have given enough time to the deceased to think over and reflect on the matter. As such, a gap of over a month would be sufficient time to resolve the.
You do one thing in all the judgments you cited.
I have marked relevant paragraphs in the first page.
No, you're not. No. Have you marked?
Yes, sir. First page index, I have given up relevant paragraphs in the last column.
Okay. Okay. Have you gone through?
I have given them a copy.
Okay. I will go through. No need not to. I will go through. Yes. What is the summary? I am reserving it. So suffering for the petitioner, so suffering for the estate. Learned for the respective parties have concluded their argument. The learned PP has produced the certified copy of the CD. Let the same be kept with the record. CAV.
Grateful, my lords.
Next.
I am for the state.
Yeah, it is your lordship. তোমারটাও কিন্তু লাগবে judgment দেওয়ার পরে।
Yes.
I request you to come to page number 14, which is the formal complaint, starts at page 13, the relevant portion in that 14 itself. It's a FIR dated, complaint dated 18th of March 2019.
Yes.
may I read Lordship? I, Gautam Pradhan, son of
What do you played for caution?
Lordship,
What is the case?
Lordship 420 with 34 and 120B later on added.
420, 34.
Lordship, the
Yes.
incident actually was the complaint against me that I took some money on the promise of giving a job, offering a job, and then I have not given receipt to that, and that's why I'm a cheater. So what I did, here two are the petitioners before your lordship. Number 2 was transparent from the name, from the mouth of the another accused. So lordship is well aware about the fact that it's actually a later on police pressurized the name to be put on. And lordship, if I'll take you once again, just a single line, page 14, second paragraph slide. I have given them rupees 30,000 on Monday, dated 11/3/2019, and the rest amount was to be paid today. After noting their activity, I felt that I am cheated by them as they did not give me any receipt of the given money. Lordship, straight away, I'll take your lordship to page 54, kindly. There are so many other persons whom we have already given job and everything happened, now complaint against us.
Yes, 54.
Lordship, this is the page where he has stated, paragraph number 3.
Who is the complainant? Gautam Pradhan.
Lordship, he has get back the money. Paragraph number 3, last line. Due to some misunderstanding, I have filed this. Third paragraph, that I lodged a complaint against one Sandeep Shah, Sujit Kumar Kormukar, Prashant Mukhia, Arnav Mandal, though he has not filed any complaint against Arnav Mandal, and other due to some misunderstanding. Fourth paragraph, that the matter has been amicably settled between us. Last line, I have received my money. And paragraph number 5, last. I do not have any objection and further grievances against the accused person.
So whether this document which now we are relying upon,
Lordship,
whether this is before the investigating officer?
Not at all.
I agree. But Lordship, may kindly come to then page 51 to 53.
What is the case? What is the case? 420.
Only.
And he is the person cheated. And you are relying upon this document. The matter has been settled between you and the complainant.
Lordship.
You go and charge sheet is filed.
Charge sheet has been filed.
Charge
But
framed.
not yet.
Charge not yet
So you
framed.
go and file an application.
Yes.
Because 420 is not compoundable.
Compoundable.
Go with the to the trial court and file an application.
And moreover, lordship, there are other 4 persons who were actually cheated
That
by
is
this.
different thing. The court can, if he is nursing, he can go and file an
Ah,
application.
yes.
Lordship, at least petitioner number 2 is not at all named anywhere. So he can, against him, it should be questioned.
Okay.
No,
Lordship, there may be
in 161 statement, in 161 statement that the name of petitioner number 2 has been transpired that
See, with regard, the case has been initiated
Lordship.
by the police
Lordship.
on the complaint made by this person,
Lordship.
Gautam Pradhan.
Lordship.
That is only with regard to the 30,000
I agree.
rupees. With regard to the 30,000 rupees, now as per this page 54, you have paid the rupees 30,000 to Pradhan, and Pradhan has given you an affidavit stating that due to misunderstanding, he has made a complaint. Now he received the amount, he didn't proceed.
Lordship.
So with regard to, the other persons were not named, but he has also stated that he has made an understanding. So once it has been come with this, all the persons will.
Lordship may direct that
What?
specifically.
Well, I will pass an order. I will dismiss your application, but you are liberty to take appropriate step before the
Yes.
appropriate court for filing an application
Yes,
for settlement.
Time-bound manner.
Lordship, one indulgence, this Gautam Pradhan lodged the complaint, he is the de facto complaint, but after initiation of the investigation, it came that one Pranoy Rai, one Tarok Pradhan, from all of them, just. It is the outcome of the investigation. It is not necessary for each and every transaction, separate complaint has to be lodged.
Cause of action.
Cause of action is, cause of action, but this is out of same, means same
Same,
intention, out
But
of same intent.
not this 30,000.
Not this 30,000. Taken rupees
How you can take this cognizance on this
No,
affair?
actually 80,000 and 30,000, 80,000, this is an organic company. Organic company, and they are taking money from different persons for giving a job. For giving a job. And on same day, on the same day, this type of transactions took place. On the very same day. And among them, Gautam Pradhan came forward and lodged the complaint. And now he is relying on the affidavit, affidavit certified by notary public. What is the authenticity of this affidavit? First of all,
That's why this court is telling.
Yeah.
That's why the first question the court has asked whether this is the affidavit which was in the knowledge of the complainant, which is the knowledge of the investigating.
Not at
officer or
all. Not at
It
all.
was not. So
Yeah.
that's why the investigating officer has not taken into consideration.
Mhm.
Otherwise, what the investigating officer ought to examine the complainant whether he has executed, and he could have filed the final report on the basis of this report. If it is not, and then under the 482, the court cannot go into the
Documents.
Correct. If he is relying upon this document, he is relying upon the document, I am dismissing it. He can take the benefit of the document before the trial court by filing appropriate application.
Appropriate application.
One indulgence. Lordship may kindly neglect the idea Lordship is impacting. So
No, trial court should consider it on merit.
Say, relying upon this document, you can free to rely upon this document before the trial court.
Trial court will consider in accordance with
In
law.
accordance with
In accordance with.
kindly.
What time bond?
Lordship is coming from 2009.
So you are filing an application when you.
In 2025.
Why so delay? Why so delay?
What, this 482?
When the FIR was, when the FIR was chalked out? 2009, when the charge sheet was filed?
It's in 20.
2009.
2019.
2019, after 10 years.
2019. FIR 2019.
2019.
2019.
When you received the charge sheet?
26.
Then
Ah.
what has happened? 22.
And two accused are still absconding.
When?
Two accused persons are still
Then-
absconding.
They are
Wha-
So suffering for the petitioner, so suffering for the estate. The petitioner has filed the present application, praying for quashing of the proceeding in connection with FIR number 51 of 2019 dated 19th March 2019. PS Sadar under section 420(34) of the IPC, pending before the London Court of Chief Judicial Magistrate, Sadar, Darjeeling, being GR case number 91 of 2019. The counsel for the petition submit that on the basis of the complaint dated 18th March 2019, the police has initiated the above case, and after the investigation, the police has submitted charge sheet. Initial charge sheet on 19th, on 26th.
June.
26 June 2020. Complaint कब है 2019 है ना? हैं? 2019. And filed the charge sheet on 26 June 2019 for the offence under section 420(34) of the IPC, read with section 120B of the IPC. Police counsel for the petitioner has relied upon, and the counsel for the petitioner submit that the case has been initiated by the police and the initiated on the written complaint of the complainant on the allegation that the complainant has given rupees 30,000 to the petitioner on the pretext that the petitioner will make necessary arrangement. No, it is not there. Only I have given the 30,000 rupees. Submit that as per the complaint made by the complainant. क्या लिखा है?
Also, for the petition of submitted the case initiated on the written complaint of the plaintiff on the allegation that the
on the allegation that, the complainant, Baki Kato, the complainant has paid rupees 30,000 on 11th March 2019, and the rest amount was to be paid on 12th of March 2019. But the petitioner noticed, but the complainant noticed that the petitioner has cheated the complainant and has not given any receipt of the rupees 30,000. Accordingly, the case has been has made the complaint. Police.
Complainant presume that he is cheated.
Police. In counsel for the petitioner, draw the attention of this court to the complaint dated 18 March 2019, wherein in the complaint it is mentioned that the complainant presumed that the petitioner has cheated the complainant. Okay. The petitioner has filed this application relying upon, where is that affidavit? 54. Relying upon the agreement, relying upon the affidavit affirmed by the complainant, Mr. Gautam Pradhan, dated 11th November 2021, before the notary public, wherein the complainant has stated that he is the complainant of Sadar PS case number 51 of 2019, corresponding to GR case number 91 of 2019 under section 420(34) of the IPC, but the matter has been amicably settled between us with the help of the family members and other well-wishers outside of the court, and he has received the money. In the affidavit, he has further stated that he do not have any objection and further grievance against the accused persons if they are discharged or acquitted from the above case. Full stop. So number next. On the basis of the said affidavit, the petitioner has filed the present application for quashing of the FIR and for quashing of the proceeding. Full stop. This court find that this affidavit has been affirmed by the complainant after filing of the charge sheet. Now, after filing of the charge sheet, this document is not with the investigating officer and not the part of the case diary of the case diary. For the in the proceeding under section 482 of the Code of Criminal Procedure, the court cannot go into the document which is not the part of the case diary or the charge sheet. Not the part of the charge sheet. Case diary, not the part of the charge sheet. And as such, this court is of the view the document which the petitioner has relied upon for quashing of the proceeding, this court cannot invoke the provisions of 482 of the CRPC by quashing the proceeding. In view of the above, CR number so dismissed. However, it is made clear, the petitioner is at liberty to take appropriate steps before the trial court. However,
the petitioner has the
liberty to take appropriate steps before the trial court, relying upon the said documents, relying upon the affidavit dated 11th November 2021, executed by the Gautam Pradhan in accordance with. If any steps has been taken by the petitioner in terms of the said affidavit, the trial court can take appropriate steps, pass appropriate order.
One in the state raised objection.
Order in accordance with law.
Correct. One line state raised objection.
What?
State raised objection in this matter. One line for this. They're already written.
उससे पहले पैराग्राफ कर देना, so suffering for the estate and raised objection, submitted that. So suffering for the estate and submit that the document which the petition is relied upon cannot be taken into consideration under section 482 of the proceeding. In the present proceeding. In the present. Published.
Lordship has small indulgence. 6 months time frame maybe can. At least 1 year lordship.
Go tomorrow you file it. Yes. Huh?
For the statement.
Yes.
Right.
Yes. Miscase is allowed. Yes, you have taken instruction.
Yes, my lord.
Yes, what instruction you have taken?
My lord, after if the impugn order, my lord, the client is paying, the opposite party husband is paying the money as per this order, my lord, 11,000 till he has paid 11,000 on 8th of October, 8th of November.
What you have prayed for?
I renewed my prayer for compensation as the child died in want of medical express.
Yes.
Since there is an execution case pending before the trial court, the amount is 5,02,000. And thereafter, my lord, passing of this order, this is not this order was not passed under Domestic Violence Act, my lord. It was under, my lord, 125 CRPC.
Sir, what you have prayed for before this court? Tell me this.
My lord, kindly make application, second supplementary application.
Supplementary application. Yes. Pays for consequently compensation at the tune of rupees 50 lakhs. How in the revisional application the compensation can be granted, sir?
Yes. Sir, ask them to pay the dues.
What? So in the revisional application, how?
My lord, they are
You take appropriate action.
They are taking up this criminal revision application every time when the CJM court is passing any order. Kindly see, my lord. That's why I need to go from the first date, my lord. Kindly see.
Sir, what you have, what application you filed before this court? Revisional application. Quashing of the proceeding initiated by the wife. Correct, under the domestic violence.
Not wife, my lord, husband.
Sorry, husband. Husband?
Yes, my lord, the revision was preferred by husband.
Who has filed the revision? You have filed the
Yes,
revision.
Before the trial court.
Trial court, my lord.
This revision, who has filed this revision application?
This revision application has been filed by the wife.
For what?
For setting aside the order passed by the session court in criminal revision number 42 of 2020.
Where is that? Where is the order?
Page 95, my.
The matter is sub judice before the session judge. It is not.
Where is the certified copy of this order?
My lord has seen
Certified copy of. Huh? Where is the certified copy of the order?
After the affidavit.
Acha, this one. The application, you had preferred the application, revisional, who has preferred the revisional application? They has preferred the revisional application. Where is the original order? Where is the original order?
Page 93, my lord.
Page 93.
Starting from
What the magistrate has passed an order?
15,000, 10,000 worth.
10,000 to wife and 5,000 to the minor. Minor, 15,000. And that's all.
That was reduced to.
So, okay, 15,000.
8,000.
And the London court, the session judge has reduced from to 8,000.
As interim.
As 8,000. Correct.
He was paying 11,000 prior to death of the minor.
8,000 and 3,000, 11,000. 4,000 has been reduced. Yes. He was paying.
Prior to the death of the minor, now
Correct.
he is paying only 8,000.
Yeah, correct. So what you want now? Now the son died. So what you want?
The expenses which incurred, the medical expenses, that he has not paid.
So you go on in the on merit,
The
case is pending.
We have already filed the execution case, but since this matter is pending before the, in this criminal revision, the trial,
okay, I am
execution court is
disposing.
unable-
I am disposing of this. Now your son died. 3014. The London Trial Court has passed. The session judge has passed an order with regard to the 11,000. So let he paid the 10,000 to you. 10,000 to you.
Well, that's a good order.
10,000 he will pay and go on merit.
The case, the revision application before the learned session judge could be is still pending. And as per the order.
The interim order.
Yes.
So I am disposing of the total revision application. You go to the magistrate court and file your return you file the return objection in the 125 application.
Oh,
What is the
Sessions Court you have appeared?
Yes, I have appeared and I am regularly paying the amount as ordered by the learned session judge.
Sessions Court, the final
You-
hearing has not been there.
Yes.
You have filed the revisional application before the
Yes.
sessions.
Yes, my lordship.
Sessions court has passed an interim order reducing the 15 to 11.
Yes.
Correct.
Yes.
Now he filed the revisional application before this court.
Yes.
Now in the meantime, the son died. So the 11,000 has been reduced to 8,000. So now I am disposing of the revisional petition itself of the session judge, directing you to pay rupees 10,000 till the disposal of the maintenance application
Before
and
the learned
maintenance
magistrate.
before the magistrate will decide on merit.
That has been decided by.
What?
It has disposed.
Which disposed?
93 is the final order, my lord.
This is a final order.
Yes, ma'am.
Okay. Then I am telling you pay the 10,000 and the revisional application be disposed of in accordance with law by the.
Yes.
What is it? Correct. So and so suffering for the petitioner, so and so suffering for the opposite party, so and so suffering for the state. The petitioner has filed the present application, being aggrieved and dissatisfied with the order passed by the learned sessions judge, Kuch Bihar, in criminal revision number 42 of 2024. White order number 1, dated 27th September 2024, wherein the learned session judge had reduced, has passed an interim order by reducing the maintenance amount of the wife from rupees 10,000 to 8,000 and maintenance amount of the child from 5,000 to 3,000, total in rupees 8,000. Full stop. During the pendency of the present revisional application, the son of the
No, my lord. Sorry to correct, 11,000.
8 or 3, 11, total in 11,000. Na?
8 and 3, 11,000.
11,000. In total 11,000. ঠিক আছে? Full stop. During the pendency of the present revisional application, the son of the petitioner wife died on, and son of the parties died on 19th December 2024. Full stop. 2024. This court find that the London magistrate has passed the order on
the 10th of June.
on 10th June 2024, directing the husband to pay rupees 10,000 being the maintenance to the wife and 5,000 per month being the maintenance to the child. But the learned session judge has reduced the amount of rupees 11,000 in total instead of rupees 15,000. Full stop. Now the pendency of the case, the child, unfortunately, the child passed away. In view of the above, this court is of the view the petitioner and the husband shall continue to pay rupees 10,000 till the disposal of the revisional application pending before the learned session judge, and the learned session judge is directed to decide the revisional application filed by the respondent husband in accordance with law within as early as possible.
My lord, kindly frame a time period.
As
because-
early as possible. As early as possible.
Extension is-
The CRR
Right, my lord.
consensus disposed of.
Because the execution case is pending and the case is decided. Deeply obliged. Deeply obliged, my lord.
আমি এখানে বসেছিলাম উঠতে যাচ্ছিলাম দরজা খুলে দিয়ে আমরা কাজ সারাদিন কি করছি যাচ্ছে না হ্যাঁ আগের দিন লিস্টে রয়ে গেছে আর বেরোচ্ছি তো লিস্টে দিন থেকে বেরোবে কেন সেগুলো আছে এইবার আমি তো উঠে গেছিলাম সরকারি তোদের কেসটা কত দাদা কোথায় প্রোগ্রাম কোথায় শুনে এই ঘটনা আপনি এই কারণে আসলো না কালকে মে হেল্প আছে হ্যাঁ দুটো মিলিয়ে জন্য না ওই আমাদের ইনস্টলমেন্টের অনলাইন আচ্ছা ঠিক আছে আমি এখানে চলে এসেছি মানে বলছি অনলাইনে কথা শোনো আরে কিন্তু তারপরে ওই পুরো পড়াতে কাজল তো আগে বলে এসেছিলাম বড়নিতে চলে যাবেন বড়নি আলাদা করবেন আমার ফোন করে দেবেন এবারে কোনো দাও হ্যাঁ তাহলে আসবে ভালো লাগবে কাজল তো ভালো লাগবে শুনে দিই এরপর আমার নাম্বার আছে তোমার কাছে এই নামটা আপনার মেলা চলতে আপনি হাইকোর্টে তো ওখানে আমি না আমি সিএম আমার আমি সিএম ওখানে আমি 2019 থেকে আছি 2019 থেকে আছি আমি আগে সিনিয়র ফ্যামিলি ছিলাম ক্রিমিনালে তারপর আমি এমপি হয়েছিলাম মানে যদি যান এখন তো ব্রিজটা ওদিকে যেতে দিচ্ছে না এদিকে একটা ভালো রেস্টুরেন্ট আছে বড়ডি মতো আপনি বলে দেবেন আমি ডিসকাউন্ট করে দেবো ব্যবস্থা করে যদি যান লাস্ট করে দিবেন আমি দিয়ে দিচ্ছি কোন বাড়িটা আচ্ছা ওই তো রেজিস্টার আইসাই করছিস না খুব ভালো আছে আমি তো মোবাইল চা খেয়ে পড়বো চালটা ভালো চা খেয়ে খাবো হ্যাঁ মোবাইল